Ladies and gentlemen, distinguished guests, it's time for us to start now. It's my pleasure to welcome you on behalf of Secretariat of the Ljubljana Arbitration Center on this important event. I'm glad that we gathered quite a lot of people today are here. I'm sure that they will be interesting, and just let's start so that we will be on schedule. Before we begin, let me briefly highlight today's schedule. We will start with the welcome addresses and the keynote lecture, followed with the session 1. Then we will take a coffee break at 11:15. We will then continue with session 2 until lunch. Lunch will be served at 12:45, and then our final session will take place after the break, followed by concluding remarks. We kindly ask all speakers and participants to respect the allotted time so we can keep the conference running smoothly. 5 minutes before the end of the panel, if it will be necessary, I will use this, not a Christmas bell, but bell for today, so that you will keep on time. Now we will begin with the welcoming addresses. Please join me in welcoming Magister Marko Đinović, Executive Director of the Chamber of Commerce and Industry of Slovenia, and followed by Professor Dr. Vesna Rijavec, University of Maribor Faculty of Law, and Vice President of the Ljubljana Arbitration Center, who will deliver the welcome address instead of Professor Dr. Aleš Galić, who is unable to attend the event due to unforeseen circumstances. So the floor is yours.
Barbara, for this kind introduction. Spoštovane dame in gospodje, dobrodošli na Slovenski arbitražni konferenci edicija 2025. Now I will switch to English. Ladies and gentlemen, distinguished speakers, colleagues and friends, it is indeed a great pleasure and honor to welcome you to the 2025 edition of the Slovenian Arbitration Conference here at the home of the Slovenian economy, the Chamber of Commerce and Industry of Slovenia. As the host institution and the founder of the Ljubljana Arbitration Center, we are particularly proud of the center's remarkable tradition. The LSE has been resolving disputes since 1928. Indeed, an impressive 98 years of continuous service, and its centenary is fast approaching. Today, the LSE is administering significant international and domestic arbitration with an aggregate value exceeding well over 200 million euros. This is a clear sign of the trust that the parties have vested in its professionalism, independence, and high-quality administration of cases. This year's theme, Evolving Trends in International Arbitration from State Involvement to Construction Dispute Management, could not be more timely. We are living in a period marked by rapid developments in international commerce, increasingly complex investments, and above all, rising expectations from both state entities and private actors. In such an environment, arbitration remains a crucial mechanism that offers clarity, predictability, and fairness. I am confident that the discussions ahead will shed new light on current developments, spark fresh ideas, and strengthen cooperation within our arbitration community, which is, as we can see, very big. At the Chamber of Commerce and Industry of Slovenia, we firmly believe that effective dispute resolution is a cornerstone of a competitive and trustworthy business environment. Your expertise and engagement are essential in helping us fulfill this mission. Let me conclude by thanking all speakers, moderators, and above all participants for contributing to this year's conference, and by expressing appreciation to our colleagues at the Ljubljana Arbitration Center for their long-standing dedication and excellence. I wish you an inspiring and productive day of discussions. Thank you.
dear esteemed guests and colleagues, I have to apologize my colleague Aleš Galić, who authorized me to address you at this event, and I'm delighted to note that we have gathered in such a large numbers, which proves that we are on the right track in working at the Chambers of Commerce, who is obviously supporting its arbitration. And of course, the conference returns after 4 years hiatus with the aim of reconnecting those interested in the arbitration community in these regions and beyond. I hope that today's topics will provide intriguing ideas for progress in both arbitration theory and practice. Allow me now briefly present the designed program and the speakers. Besides environmental sustainability, today we must also address how to leverage the potential of artificial intelligence. This is some kind of buzzword to enhance procedural efficiency. It's necessary. However, this requires careful consideration of ethics, data confidentiality, and impartiality. Today's another demanding aspect involves the finding regarding the arbitrability of various disputes, which facilitates the decision-making process for arbitration clauses, for including arbitration agreements. A specific issue is the conclusion of arbitration agreements in the public sector. Next are multi-tiered dispute resolution clauses, which are becoming increasingly common. Furthermore, today's focus shifts from dispute resolution to dispute avoidance. Proactive risk management and the inclusion of dispute avoidance mechanism in contracts are key to reducing costs and maintaining strong business relationships. Special attention will be paid to construction projects, as we heard, which remain the main source of complex arbitral disputes due to their complexity, longevity, and involvement of multiple parties. Arbitration is a living and dynamic discipline. The common thread among all topics is the need for constant adaptation and innovation. However, I believe that the Ljubljana Arbitration Center's very modern rules of procedure enable efficient decision-making on international dimensions through the selection of the most competent arbitrators, not only domestic ones, and the conduct of proceedings in the language chosen by the parties. Ljubljana Arbitration Center offers different case management ensured also by encouraging the proactive approach of the arbitrators and by the efficient support by the Secretariat. And we are delighted to have outstanding experts participating with us today across various sessions. And first, I should introduce Jean-François Bélis, who is highly respected engineer from the renowned firm Van Beel and Bellis from Essen. He will be delivering the opening lecture focusing on the dynamic relationship between international commercial arbitration and EU competition law. But what is the benefit that we have, our keynote speaker today, is that he is not a lawyer. He will join us and try to give another aspect how such a renowned expert who is invited to be engaged in cases all around the world, not so much in Germany as he told me, but in Netherlands, but also in different countries of Africa. And of course, his engagement is so important to give another view so that we lawyers that we are involved in the decision making can understand the facts and the lege artis, so what is another expertise. And his expertise is in FIDIC conditions, so this is also something that we will deal with today. Another, Peter Rižnik, an experienced arbitrator and founder of Rižnik Disputes, will moderate the session, the panel on the complex topic of the state's involvement in international arbitration, guiding the discussion on experiences and challenges. This is also that we chose this year that we need to start more recognizable discussion how the state entities can be sometimes more open to include some arbitration clauses in the business relationships. And of course, we have here also Magister Nataša Pintar-Gosenca, the head of International Department of Slovenia State Attorney's Office, and she will certainly, drawing upon her extensive experience, what are the challenges faced by state attorneys regarding arbitration. Next, David Premlj, senior partner, Rospelhan Prelesnik Partners, Ljubljana, Slovenia, will address the significant changes in intra-EU investment arbitration following the ACMEA ruling. His presentation will analyze the post-ACMEA landscape and its implication for investment protection within the EU. And next, I'm sorry for the pronunciation, Alptag Tokescher, LLM, an expert in Alp arbitration based in Zurich, Switzerland, will provide insights into the state as a client, focusing on the specific legal and strategic nuances that arise when representing a state in international arbitration proceedings. Next, Matija Urankar, partner at law firm Senica Partners, Ljubljana, Slovenia, will address the complex issue of managing parallel proceedings, specifically the conflict between arbitration and domestic litigation, really a very difficult issue when both are brought against the state, offering strategies for effective coordination. My dear colleague, Dr. Petra Richar, attorney in law, Richard Tuvenin, dispute resolution in Zurich, again, Switzerland, specializing in dispute resolution, will moderate the discussion on multi-tiered dispute resolution clauses, focusing on how these clauses are structured and implemented in practice. Professor Dr. Tomislav Boric is coming from University of Graz, and he is also known in arbitration community as an arbitrator and a specific expert in commercial law, and he will discuss dispute avoidance through contractual risk allocation. His contribution will focus on proactive measures and careful drafting to minimize the potential for dispute before they arise. Recognized expert Christopher Sepela, independent arbitrator, expert counsel from Paris, France, but origin in Finland, will online provide a detailed look at dispute management tools in FIDIC. Nastja Merlak, partner law firm Jadek Pensa, Ljubljana, will offer counsel's perspective on the practical drafting and application of multi-tiered dispute resolution clauses, sharing insights from a litigator's point of view. Nate Slahne, general manager, E.ON Slovenia, Ljubljana, presidium member of the permanent arbitration LAC, will represent the business side, explaining how businesses structure multi-tier dispute mechanism to align with their commercial goals and minimize disruption. Petja Plausteiner, attorney at law, law firm Plausteiner, Ljubljana, an experienced attorney in the field and presidium member, will moderate the session dedicated to intricacies of construction, dispute, and arbitration. Robert A. Worth, arbitrator, adjudicator, and mediator, Worth Consult. Germany will highlight the role of FIDIC and the engineer as a central player in construction projects, particularly in minimizing delays and preventing disputes. Thierry Linares, Senior Managing Director, Consulting Paris. France will delve into the technical aspects of construction disputes, focusing on extension of time claims and delay analysis, which are crucial for assessing liability and compensation. Dr. Maja Menard, attorney and arbitrator, partner law firm Fatur and Menard, Ljubljana, Slovenia, will provide practical guidance on effective case management in construction arbitration, offering strategies for moving from claim to award efficiently. Magister Tamara Manasijević, attorney at law, Vienna, Austria, will focus on the fundamental principle of evidence in this context, addressing the rules and practical application of the burden of proof in construction arbitration. Last but not least, Magister Andrej Ivans, Rico DOO, Director of Environmental Engineering, Ljubljana, representing the contractor viewpoint, will discuss a proactive approach to conflict prevention. And now let us proceed to the substance of the matter.
Thank you for the welcoming addresses. Now we move directly to our keynote speaker. It's my pleasure to invite Mr. Jean-François Belly to deliver the keynote lecture. And just a kind reminder, the time slot is 30 minutes.
No. Thank you for...
I'm so sorry to interrupt you at the beginning, but I made the wrong introduction. So this was my fault. And of course, I just, if you can introduce yourself correctly. So I apologize for this.
No problem. Well, first I want to thank the organizers of this conference for having invited me to what promises to be a very interesting event today. So I'm a lawyer, but also a professor teaching competition law at the University of Brussels. A long time ago, I also spent some time at the Court of Justice as a référendaire to the then first British judge at the court. So that was a long time ago. And my experience is about competition law, and in fact, in that respect, I have sometimes acted as an expert on competition law in arbitration proceedings. And I have to say that I have found it always more, easier to act on the side of the dispute that was challenging the application of competition law in arbitration proceedings, because I sense that for arbitrators, the injection of a law like the EU law, which allows a party to claim that the contract, which is at the core of the dispute, is null and void, is seen as something which only desperate lawyers use, because they have nothing better to argue. And so I have always found it much easier to defend the case that EU competition law did not apply to the dispute at issue, something which sometimes is a very important issue. In my last case, in which I acted in an arbitration proceeding, the EU competition law issue was worth €1 billion. And the arbitration panel declared that EU law had not been violated. So now let me engage in my presentation. And essentially, I will discuss the interaction, sometimes very aggressive interaction, between EU law and arbitration in two respects: investment arbitration involving member states, where EU law has had a very destructive impact, and arbitration and EU competition law, where I feel that the antagonism between the two sets of laws is much less. So very briefly, on investment arbitration. Of course, we all know what is investment arbitration. Bilateral investment treaties have been entered into by many countries in order to provide confidence to investors that their position when they invest in the country will not be affected by subsequent changes in laws or regulations. So it's a very important tool to attract investors. Now, the problem with EU law is that EU law seems to require member states to not to entrust their disputes to arbitration. And the Court of Justice has raised this issue to an extraordinarily high level, because you have to understand how the EU system works. In the EU system, the EU courts, General Court in Luxembourg and the Court of Justice also sitting in Luxembourg, perform essentially three functions. First function, they are administrative courts reviewing appeals against decisions of the Commission and other EU institutions. Second function, they adjudicate disputes between EU institutions and member states themselves in some cases. And the third function, and this is where the EU law comes into conflict with arbitration, the arbitration world, is ensuring that EU law is applied by EU member state courts. EU law, the Court of Justice declared a long time ago, is directly applicable in EU member state courts, and the Court of Justice has a tool to ensure that this is so, which is the request for preliminary rulings, which member state courts may use to send questions of EU law directly to the Court of Justice. But only member state courts have that power, not arbitration panels. And I think this is the root cause of the problems that have been experienced when dealing with arbitration and EU law. Now, the case which will be the subject of discussions in the first panel, as I understand, is Achmea, a case in which the Court of Justice essentially decided that it was illegal under EU law to entrust a dispute about investment to an arbitration mechanism. The court said that these kind of issues could only be handled by EU courts. I will quickly go through the slides in the interest of time. The court made it clear that Achmea had retroactive effects. It applied even to cases which had been started before Achmea was issued. Mikula pushed this issue even to a further stage, in which the Commission also intervened in the dispute and said that a member state court that awards damages to a company which considers that the rules of the investment treaty have been violated is receiving illegal state aid. And so even the grant of damages by a court or by a state outside of the context of the arbitration mechanism is also illegal under EU law, so meaning in effect that the whole system of protection of investment in the EU has been nullified. It's impossible to enforce it even at a member state court level. But I think this issue will be discussed further in the first panel, and I will stop here. I now move quickly to the other aspect of the dispute, the use of EU competition law to invalidate arbitration awards in disputes between private parties. I will skip over the applicable provisions of EU competition law, which I assume all of you know well. And I will start with Benetton, which is the foundational case. This is a case in which my firm was involved. We represented Benetton. And at the hearing before the Court of Justice, in which this case was argued, sitting in the room where justices from the US Supreme Court, which had just issued a judgment stating that an arbitral award in the US could be challenged under US antitrust law. So we saw this as a signal that the court was moving in the same direction, which it did. But the ruling in Benetton, also known as the Eco-Swiss case, was a kind of Pyrrhic victory for Benetton. We did not represent Benetton in the arbitration proceeding, only in the court proceeding. And the mistake that Benetton did was to challenge the arbitration award that granted damages to the other side. The proceeding was a two-stage proceeding. There was first an arbitration award on the substance, and then an award on damages. They did not challenge the first award. And under Dutch law applicable to that case, the second, challenging the award on damages on substantive grounds, was inadmissible. So the Court of Justice said that EU competition law can be relied on to establish that an arbitration award violates EU competition law, but the court said that this does not interfere with local procedural rules, and so in effect Benetton was unable to take any benefit from that judgment. Then I move to the area in which there has been a lot of controversy, the issue of EU competition law, arbitration, and sport, and especially the role of the Court of Arbitration for Sport, the CAS, in Lausanne, which hears appeals against decisions made by most sport bodies located in Switzerland. The first case in which this issue was raised is ISU, International Skating Union. I was the lawyer representing ISU in that case. This was a strange case in which the Commission challenged the rules of the International Skating Union on the ground that when the ISU was ruling on request by third parties to organize an event, the ISU had too much discretion in deciding whether or not to approve that event. This was a very misguided case because the ISU is one of the poorest sport bodies in the world. Its two sports, figure skating and speed skating, attract attention essentially every 4 years in the Winter Olympics. And for the rest of the time, there is not much interest in them, especially speed skating. But there is some interest for third-party events for figure skating, and the ISU had always approved all of them. The reason why a complaint was filed against the ISU is that the ISU prohibited participation of its skaters in an event which was supposed to take place in Dubai, organized by a Korean company which was promoting a new concept of speed skating competitions in which spectators could bet on the spot. So based on a model which exists in Japan and Korea for cycling events. And the ISU thought that this concept was against its rules prohibiting betting and support for betting, and so refused to approve that event. Now, the Commission did not really address that Dubai event addressed only the rules and said, well, your rules are not sufficiently clear. We challenged the Commission's decision in the General Court, and the General Court said made very interesting comments on the CAS aspect, because the Commission in its decision had said that the problems created by the ISU rules had been aggravated by the fact that the ISU decisions were appealable to the CAS, which was a very odd way of looking at things, because the ISU had introduced this CAS appeal fairly recently. Before that, there was no appeal. So creating an appeal, giving rights to athletes, should have been seen as an improvement of the athletes' position, but the Commission said no. This makes the infringement worse, because the CAS can rule on these matters without considering EU competition law. The appeal is before the Swiss Federal Court, so the whole dispute escapes from the scope of EU competition law. The General Court said no. It's legitimate for a sporting organization to have an appeal handled by the CAS, which is an international jurisdiction. There is nothing wrong with that. But the two skaters which had filed the initial complaint, which led to the Commission proceeding, appealed to the Court of Justice, and the Court of Justice agreed with them and said, yes, there is a problem with the CAS. When the CAS deals with issues having an economic value, it's okay if the CAS rules on purely sporting issues, but if there is an economic angle which may involve EU competition law, this is a problem. The court added, of course, EU competition law only applies to practices which affect competition in the EU, which was an indirect way of saying maybe in the case of Dubai, which was the location of the event which the ISU prohibited, EU law would not apply. But that ruling caused consternation in the sporting world, and consternation at the CAS level, because it raised the question of whether arbitration by the CAS was still consistent with EU law. Even some people considered moving the location of the CAS, but I think that none of those concerns are justified following the very recent judgment issued by the Court of Justice last year, the Serein case involving sanctions, which had been imposed on a Belgian football club because it violated rules on third-party ownership in the football system. Those sanctions had been upheld by the CAS, but then the football club, the Belgian football club, decided to bring a suit in Belgium, so challenging the validity of the sanctions. And the Belgian court immediately responded, well, you have signed, you are a party of an arrangement under which you have given jurisdiction to the CAS. And so I cannot address your dispute. Your dispute was the subject of arbitration, and I can no longer deal with it. But before dismissing the case, the Belgian court sent a request for preliminary ruling to the Court of Justice, which I think clarified the situation as far as the CAS is concerned. The court said, did not say that the CAS, using the CAS is illegal as such, but the court said that these, the rulings by the CAS can be challenged before domestic EU courts on grounds of EU competition law or EU free movement of person law, which should be regarded as a kind of public policy exception. So a mechanism which is known in the arbitration world. So the existence, in my view, the existence of this right of challenging awards by the CAS inside the EU on public policy grounds means that, in fact, nothing must be changed in the system of sport arbitration. Simply, as far as the EU is concerned, there is the fact that the awards will not necessarily be final because it can be challenged under EU competition law in any member state court. So I think that I'm still within the time limits. I will stop here to conclude that I know EU law is sometimes regarded with a great skepticism, not to say hostility, in the arbitration community. I think that those feelings are certainly justified in the field of investment arbitration, where EU law has caused very serious damage. But as far as competition law is concerned, I think that the damage is very limited. In fact, you have to regard EU competition law as a public policy law which can justify a challenge to an arbitration award. And I would say it's very close to business as usual, nothing to especially worry about. And I will stop on this optimistic note. Thank you.
Thank you very much for your presentation. And we now enter session 1, moderated by Mr. Peter Riznik. I kindly invite all the speakers to take seats on the stage and proceed with the discussion. So, thank you.
Let's see. Thank you very much. Hvala. Tako, dobro jutro, dober dan. Welcome everybody to to the conference, but also to our panel. Thank you, of course, to Jean for this inspiring speech. And especially, it was very good to see you were involved and your firm was involved in the EcoSwiss Benetton case. We have heard about that, I think, in my first ever arbitration. That was very heavily cited. So finally, I see someone that was actually involved there. Now, if we move to our panel, we are going to be covering the role of states and state-owned enterprises in international arbitration. We will have to be fairly expeditious. There's 4 excellent speakers on the panel, and we have 1 hour. So we'll try to do it just like we do in arbitration, fast, efficient, as we always do. Now, there are quite some considerations particular to the cases where states or state entities as well, in some cases, are involved. Our speakers will be focusing on these issues from 4, let's say, different perspectives. How we are going to, we wanted to do this so that we are not, let's say, boring you too much. We don't want you to be drifting off on your phones. We will try to do it very, let's say, interactive. We would also like to include you. We will first have each of our speakers is going to have a 5-minute presentation, and then afterwards we will have a discussion, all of us, on that particular topic that they are covering. Now, Professor Riavec has already kindly introduced my speakers, so I will not be spending too much time on that, but I did want to say a couple of very short things about them. We start with Natasha, who's going to be our first speaker. Natasha Pintar-Gosenza, she's a senior state attorney. She is the head of the international department at the state attorney's office in Slovenia. And she's dealing with cases before she's representing Slovenia before the European Court of Human Rights, Court of Justice of the European Union, and now also in, as far as I know, there is 1 current pending arbitration against Slovenia. Are there 2? Okay, so I haven't been paying too much attention. So basically that is what the state attorney's office does. Then we have David over here, David Premlj. He's a senior partner at Royce Pelha Prelesnik and Partners. And he has spent a good part of the last decades representing an investor in a big ISDS ICSID arbitration. He will be covering that aspect. And then we have Alp over there. He is a partner at Alp Arbitration, and he has represented Romania in the Mikula 2 case, which we have heard about the Mikula cases, and Turkey as well, right? So also has quite some experience in representing states. And then we have Mattia over there. He is an attorney at law at Senica and Partners, and he's a partner there. He heads the Department for Constitutional Law, and he has recently been involved in a case involving insolvency issues, and we will also cover that aspect there. So now, I might be quite annoying keeping the time, which reminds me, since we do have 1 hour, this is all for your own good. If I may cite myself when I speak to my daughter, you will, everybody will have 5 minutes. I'm going to start timers every time. And we will also have a discussion afterwards, which will hopefully be a little bit longer. Now, Natasha will begin. Natasha is a proper arbitration nerd. I went to the website of the State Attorney's Office, and I looked, I carefully examined the 2024 report, and I saw that the word arbitration is mentioned 131 times in the report, which is actually quite a lot. Okay, it was like 400 pages, so it's, you know. But this is not all the State Attorney's Office does, right? I mean, can you tell us what the State Attorney's Office actually is? What are its competences? What do you do in your daily work?
Yes, thank you very much, Peter, and good morning to all of you. From time to time, we discover that what the State Attorney's Office does is not really very well known, even in Slovenia and especially not abroad. So to be quite short and exact, State Attorney's Office is the legal representative of the state before national, foreign, and international courts and arbitration proceedings. So whenever you think of initiating a proceedings against Slovenian state, you will meet one of us. So this is the legal rule. Of course, there are some exceptions to this legal rule. So we can, by the government decision is done so. The representation can be given to some law firm or to somebody else, but in principle, State Attorney's Office is the legal representative of the state. So, of course, we do not do only arbitration proceedings. This is actually our latest competence we gained by 2017 State Attorney's Office Act. But before, we obtained many experience by representing the state before, especially European Court of Human Rights and Court of Justice in Luxembourg. So probably these arbitration proceedings were mentioned so many times in our last annual reports because it is quite a new thing we are learning still on, and we have the freshest experience in these proceedings. And of course also because they are so different from all other proceedings we represent the state in. So we are traditionally a state institution which deals with court proceedings, so arbitration proceedings are something that are very, very new and very different from all what we already learned in many decades of our previous work. So I don't know if you are going to question me, other questions, or shall I shall I continue? Just a few sentences more, and then I will leave the room for discussion.
You still have quite some time, so you're
Okay, okay. Coming back to arbitration proceedings, as it was already said, we have at the moment 2 pending proceedings. But from the independence of Slovenia in 1991 on, we have had 6 arbitration investment proceedings against the state. So 3 of them were before this act I mentioned before, which gave us the competence of representing the state also in these proceedings. And 3 were initiated after 2017. So 2 of them are pending, and 1 of them is coming to the end, and the other one is somewhere in the middle. What is the approach of the state so far? I cannot say that this will remain so also in the future. But as far as our experience are at stake, I could say now that the state hasn't decided to build its own group of specialized lawyers just for arbitration. But it seems that we will also in the future it's not only just because it's a lot of work to do, still coordinates all the work of all the stakeholders, but the substantive part of these arbitration proceedings, because we are not specialized in this, will be given to the law firm that we engage for each particular proceedings. So I have to stop here because I have this direction from Peter to stop when my time is run out. So I will give the floor to my other distinguished colleagues and to the audience.
No, I mean, no need to stop abruptly. I mean, I almost never watch Slovenian TV anymore, but last week I watched a little bit of this show before this referendum that we had recently, and there they had 45 seconds and I think 90 seconds. So that was really strict. I'm not going to be that strict, but yeah, thank you, Natasha, for this overview. You have ended now on the note of external counsel, and I think, the vast majority, pretty much all of the countries in the world apply this approach. They use external counsel. There is a couple, the US, Canada, they represent themselves, but they also have probably like 30, 40 people working at those offices, which can in the end be more expensive, of course, than getting external counsel. I often hear I often use the word state attorney's office when colleagues from abroad, especially like from London, they're like, how do we get business in Slovenia? They say, how do you pitch for cases when representing Slovenia? What do you do? I say, look at the website and see if they have a tender. But I mean, how do you actually select counsel?
Well, I have to say that in all these 3 arbitrations that we were handling in the past and still today, 2 of them, from time to time, or probably in all 3 cases, we were asked by external counsels even before we knew that the request for arbitration was filed. So we were asked, well, it seems that you will be the respondent party in this proceeding, so do you need anyone to help you? And well, we were quite surprised from time to time, but now we know how it works. So especially attorneys at law, I know that you watch very carefully different pages and sites announcing the potential arbitration proceedings. But yes, what is important for every external counsel to know is that we publish a public call on our website, and this is the main thing you have to bear in mind. So there are all the conditions set in this public call, and also the deadline, which is normally quite short. And then you apply, and then after the selection proceedings we have in-house, then we select the external counsel. So conditions for selecting the counsel are slightly different from case to case because it depends on the case. But in general, we look for the references. So we want a counsel with experiences in representing the state in investment arbitration proceedings. And of course, I have to mention something that is not really unimportant, or for the state it is quite important. It is also the financial consequence. So the financial part of the offer is quite unimportant for the state, but it's of course not the only and last condition, but we have to bear in mind these aspects very much, because you can imagine that even being a state, our Minister of Finance is quite financially sensitive.
I was wondering, so which is also probably relevant for the people in the room, when you do have external counsel, you probably, usually they are probably going to be from an international firm that has a lot of experience in investment arbitration. But then who covers the Slovenian law issues? Like, do you do the coordination? Do you have people also that cover Slovenian substantive law issues? Or do you look for a law firm in Slovenia? Does the external counsel look for a law firm in Slovenia?
So for now, in those three arbitration, we didn't engage the Slovenian law firm because there was a special unit organized on the level of the state, composed of state attorneys and ministries, which covered the substance that is the substance of the arbitration proceedings. And so far we covered this part, so collecting the documentation, relevant law, and also interpreting Slovenian law. But of course, I cannot say that this will remain so also in the future. So I can simply imagine also the case when we are not enough to do all this work, and we have to decide to engage also the Slovenian law firm. But so far, it was not the case.
Yeah, thank you. I mean, so this is also maybe keep an eye on the website
Yes.
for our Slovenian colleagues as well. Now, you have been representing the state, I think, for 16 years, or was it, what are the particular challenges when you represent a state? I mean, probably it can be different than, when you're representing a private company. There are maybe different interests. You have to think of the public interest. Are there any specific challenges that you can think of when you're talking to, let's say, commercial arbitration people?
Well, I have never worked in a private law firm, so I don't know your challenges with your clients. Well, I can say that our client from time to time is quite a difficult client, especially because many things are very highly regulated. And of course, the state has its own interests, of course. And we have to have all these aspects in mind when we deal with the state. So we do coordinate all the relevant ministries and other state institutions that are involved in the case. But of course, we have to have in mind also the political aspects, because you can imagine that the government itself, it has its own particular interests, which are usually or mainly not legal aspects, but political. And the most difficult, what I find from my practice, is how to translate the political interests into more or less strong legal arguments in the written observations. So this is quite an art, but yes, this is what it goes together with the state and its particular interests.
Yeah. Thank you, Natasha. Now, maybe I should stop torturing you, give the floor to somebody else. Do we have any comments from the speakers so far? David has already taken the microphone,
Absolutely.
which is good.
Natasha,
Good
we
sign.
would absolutely appreciate the opportunity to assist you and to give your co-workers some additional free time. So if you keep that in mind, we'll be happy to submit a bid.
Well, that's good to hear. Do we have any comments, questions from the audience, or maybe from, how does it look? Professor Jevec.
I would like to ask you about this very demanding issue, how to include more arbitration clauses into the business contracts with the state and state entities. What is your advice, how to do it?
Well, I have to be very honest. We are not involved in any phase of concluding any contracts, usually or normally. So when the state is signing and concluding investment treaties or commercial contracts, we are usually not involved in this phase. So we do have, as a state attorney's office, quite strong advisory role also, and from time to time we are asked upon any question, but I don't remember any such question from any ministry or any other state institution asking us what would we advise for a certain or concrete contract, either to include an arbitration clause or either to leave the resolution of disputes to the courts. So I have no mandate to talk about the position of the State Attorney's Office on this question, because we have not formed any view on this topic. But I know that some writings were already, or some letters were going around different ministries on this topic, especially for the construction contracts, which the state is concluding to include the arbitration clauses into these contracts. I don't know how it is in practice, if this was followed or not, but I know that some suggestions in these directions were done. Yeah.
I can give. I can give the example of how we did it in Turkey, if it helps, because when we started the Istanbul Arbitration Center 10 years ago, and it was similarly set up like this, only it is directly under the Union of Chambers of Commerce in the country. And as a result of and it took a lot of lobbying, both by the Chambers of Commerce and the president of the Arbitration Center, but they finally persuaded the president's legal office to actually issue a communique advising all relevant entities that are spending state taxpayers' money to say that it is okay for you to have both court jurisdictions or give jurisdiction to the Istanbul Arbitration Center. And after that, we saw quite a pick in state-involved contracts going to arbitration. So maybe that might help.
That's a good point. I am sorry, I will have to interrupt this discussion to move to, thank you, Natasha. Thank you very much. we are moving to David. We are diving deep into the underbelly of the beast called ISDS, investment arbitration. David, I said you've spent a good part of the last decade representing. I'm not sure, like, that does not mean that you are old, don't worry. But he's been representing in exit case. He's going to be talking to us about what some people would call the demise of us all, but I hope it's not as bad, which is the case of Achmea versus Slovakia, or probably more likely Slovakia versus Achmea. So, David, just what happened in the case, what happens now?
Yeah. Thank you, Peter. Thank you to the organizers for this opportunity. Professor Belli has already briefly addressed this issue, a topic that has basically fundamentally reshaped the relationship between the EU law on the one hand and the international investment arbitration. But just to refresh our minds, so let's start with the case that changed everything. So in 2018, the CJEU issued its landmark Achmea, I think the Dutch called it Achmea ruling, declared that arbitration clauses in bilateral investment treaties are incompatible with EU law. Now, why did the court do that? So the basic reasoning was, rested on three key principles. The first, the arbitral tribunals may interpret EU law. Second, they cannot seek preliminary rulings from the CJEU, as they are not national courts for the EU member states. And the third one being the post-award review of those awards is insufficient to safeguard EU law. Now, this judgment did not only make the headlines, so it actually triggered a systemic response. In 2020, a number of EU member states, not all of them, however, signed the so-called termination agreement, which retroactively ended intra-EU bids among the member states and marked basically the beginning of a new era for investment arbitration within the EU. But that did not end. So Achmea was only the beginning. Just 3 years later, in 2021, we had two additional landmark rulings, one being the Comstroy. This one is particularly interesting because it was between a Ukrainian investor and the Republic of Moldova, none of which obviously being an EU member state. The only link to the EU law was that the arbitration was seated in Paris, which means that when the Republic of Moldova tried to set aside the award, actually had to approach the Paris courts, which then had a right for a preliminary request and actually got the CJEU involved. And what the Comstroy did in addition to the Achmea ruling is that it expanded the same principles to the ECT, Energy Charter Treaty. So while the Achmea ruling only dealt with the intra-EU bids, that is bilateral investment treaties, ECT is another, is a multilateral treaty, which the Achmea ruling did not address before. Now, the second ruling, also important, is the PL Holdings ruling. And here the court closed another loophole. It basically ruled that ad hoc arbitration agreements are equally invalid. Now you have to know what the investors basically did. They objected that even if under the Achmea ruling the arbitration clause in bid is invalid, the state's conduct still formed an ad hoc arbitration agreement, simply because the state, the respondent state, took part in the proceedings, appointed its arbitration, and so forth. And the conclusion of the CJEU was that this equally applies. Now, the relevant question is, what did the arbitral tribunals do? This is something particularly relevant for our exit arbitration cases as well. Now, the majority of arbitral tribunals did not actually accept, they did not accept the ECMIA or the Comstroy objections and simply upheld jurisdictions, basically arguing that the consent under the ECT is a separate one and is a separate international treaty obligation, and that the ECMIA does not affect it. So we had a number of cases until recently. In 2022, there was a notable exception of a Green Power v. Spain, where the SEC, that is the Stockholm Chamber of Commerce Tribunal, for the first time declined jurisdiction under the ECT, citing incompatibility with EU law. Last year, we had 2 additional cases against Spain that basically also, and these were the first exit tribunals awards that actually declined the jurisdiction in these cases. So while we have dozens of cases against, particularly against Italy and Spain, due to their renewable energy policies, now we'll see how this will change in the future. Now, I see, Peter, my 5 minutes are over.
I really feel horrible doing this. I'm really not the guy to be. But I guess if we are late for the coffee break, I will never get invited to the Slovenia Arbitration Conference again. So that I don't take too much time talking myself, I do have a question, and I mentioned that Alp did actually represent Romania in the Mikula 2 case, but now the question still for you, David. Legality under EU law of state aid. So the Mikula case has dealt with that. What has been going on there? If you can just maybe present a little bit the situation.
I will be a bit around. I mean, the Mikula saga, and I will be able to tell more about that, but the case I've been involved in started in 2014, so it's not much different. Oh, yeah. The first award in the Mikula case, as far as I can remember, was in 2013. So, and still, there is a...
Just to interrupt, sorry, the Ljubljana Arbitration Center arbitrations do not last that long, right? Just...
Yeah. That is a very important aspect. Professor Bali, especially, I'm not a specialist in competition law. We have a special competition law department. But what basically the European Commission did was that it used a tool of the unlawful state aid law, to try to disrespect the awards, which disrespected the ECMIA rulings. So, for example, in Mikula, Romania, European Commission issued a decision and declared that payment is an unlawful state aid law. And we have a brand new case from 2025, v. Spain, where the European Commission as well ordered Spain not to pay and to resist the enforcement either within the EU or outside the EU. And this is particularly important issue because while within the EU, there's been quite an alignment of the EU courts or the national courts, which basically followed the CJ, EU, ECMIA, Comstroy rulings. This is not the case outside the EU. So we have cases from Switzerland, from the UK, from the US, where the investors were actually were able to secure the enforcement of the award based on similar but not equal reasons. Yeah.
I'm wondering what happens to the state, like let's say back home in the EU, when the enforcement had been secured by the investor. I mean, it was not a voluntary payment, but are there any consequences? Are you aware of any issues that happened there?
Well, in the second Mikula case, it became an issue, sorry. Well, the difference between the two cases is that they do not have any factual overlap. They were two very separate investments. But then what happened was that when the second case was pending and ongoing, we received a provisional measures request from the claimants, and they were saying that, well, we successfully enforced certain parts of the award in the UK and the US, if I remember correctly. And then they basically, they were told by Romania, which was told by the European Commission, that recollect those monies, send them invoices and collect them, and do it by any means necessary, so if you need to seize their factories and so on. And then the claimants in our case said that because they were not claiming for expropriation. So the investment was still live, ongoing. And they basically said, if Romania goes ahead with this, I may run bankrupt and I may not be able to continue my case. So second Mykola Tribunal, you have a duty to protect the integrity of the proceedings by making sure that the respondent state does not run me into the ground financially. So obviously, when these things happen and with all of tensions and the time, so it didn't come to the actual point where an intervention was required by the Mykola II Tribunal to stop bankruptcy of these companies. But the question was always up in the air, that what would be done. And I'm not a trained EU lawyer. I was trained in Turkey and Switzerland. So I will be honest with you. I'm struggling a bit in trying to understand who and who gave the European EU law some kind of a jus cogens status over any kind of international law. I fail to understand, and it might be my failure, but it is creating a big mess right now.
It's very interesting. David, you mentioned also a UK case, right? Well, I mean, the United Kingdom, as we all know, is not a member of the European Union anymore, but even there was still a jurisdiction of the Court of Justice, or how did that work?
Well, I mean, Mykola is exactly the example of this, because they tried to enforce in the UK, and at first there was the courts ordered a stay of the enforcement. However, then I think in 2020, the stay was lifted, which resulted in the European Commission referring the case to the CJEU, who that believed last year clearly said that UK was in breach of its post-Brexit obligations. And this lifting of the stay of the enforcement was not in compliance with the EU law and the Brexit agreement. But there was another case, and in the for example, in the US, I think there were 3 Spanish cases. One is called Blasket, Spain, and I mean, they were struggling to enforce that, but just recently, last year, the USDC circuit allowed enforcement, just relying upon the arbitration exception in their FSIA, that is Foreign State Immunity Act. I mean, the situation is complex now, and it's quite fragmented. I mean, you will very likely not be successful within the EU, but there are still relatively good chances of success if you try to enforce that either in Singapore, in Switzerland, in UK, US, and so forth.
Well, that's good to know. But yeah, it's a complex situation. Unfortunately, we only have 1 hour. Otherwise, we would resolve it in this panel. One more question I had for you, David, and about your actual experience in representing claimants. How do you design your claim when you are? What would be the best strategy?
Well, the question is whether this relates to the post-ACMEA era and these whole problems or not. Because, I mean, one thing you obviously have to do, you need to review whether there's been a breach of the investment treaty or not, whether it is ECT, BIT, whatever is applicable. Now, in our case, and that is, there's quite a lot of publicly available information on that, so I can discuss that briefly, but what we did is we basically filed 2 claims in parallel. One in a commercial arbitration against the state-owned entity, and the other one against the Bosnia and Herzegovina before exit. And what this did is that, I mean, I mentioned at the beginning that the whole case, the exit case, now lasts for more than 11 years because it resulted in a suspension of the exit case, because the exit tribunal wanted to learn what the decision of the local or the parallel tribunal will be, which it deemed far more competent to decide the commercial issue, especially the issues related to the ex-Yugoslavia, which involved a number of issues that the British or the American arbitrators may not be familiar with to a sufficient degree.
That's very interesting. I mean, like, I have to say that what I've thought about now, you know, like we are talking about you representing an investment, but also basically your client is a state-owned company, you know, so I mean, right, so it's kind of, it kind of fits quite well into our panel. Everybody's state-owned.
We had state-owned enterprises on the claimant side, we had state-owned enterprises
Exactly.
on the respondent side, so yes, a lot of issues.
Yeah, even like, you know, the Vattenfall case, it's also a state-owned company. So like in the end, it's not just the evil investors against the poor states, you know. I mean, no offense, but yeah. Do we have any, we have time for one more comment or question from the audience maybe on this topic? Petra, go ahead.
Good morning. I just wanted to add to David's, just to cite the case that you mentioned, because it has been discussed quite a lot. So it's a decision of the Swiss Supreme Court that was rendered last year in the context of intra-EU ECT dispute. Maybe if somebody wants to read it, I have the link to the decision itself. I can forward it, would be happy to do so. And this is a small revolution in the Swiss landscape, because the Swiss Supreme Court, that is always very, very polite in its wording, has been extremely aggressive in stating that the ECT is not, the EU law is not supreme to ECT, and that the tribunal seated in Geneva had jurisdiction to decide, jurisdiction based on Article 26 ECT to decide the dispute. And so you can imagine this is contra the whole position of the EU right now. The Swiss arbitration community is quite proud of this decision, because it simply is one instance at the moment that is brave enough to contradict what is happening in the EU. Another comment, if I may, to the keynote speech. There was an explosion of comments in the Swiss arbitration community on the last decision that you mentioned, where CAS decisions are now, they can be reviewed. So there is a big disagreement, and I think we could discuss for hours on this, whether or not this is the correct approach. That's all from me. I'm sorry for taking your time. Thank you.
Thank you.
One sentence. I hope Switzerland never becomes an EU member state.
Thank you very much. Thank you, David. We're moving to our next topic. We're moving to Alp. Let's say a bit of another side of the story. Alp has represented states. He has quite a unique perspective on the challenges when representing states. Now, so he's going to tell us about how to build the case strategy when you're representing a state, address some of the challenges. So, because there are for sure differences when you have on one, you know, when your client is, you know, wants money, wants, you know, like wants dividend payments, all these kind of things, or you have another client who also wants money, but, you know, like has a different interest, and Natasha has mentioned maybe even political interests, but, you know, public interest, they have to think about that. So, Alp, what do you have to consider?
Well, thank you very much, and thank you very much also for inviting me here to speak about this. But I think like the first issue is about what the state or the state client usually wants, and it's not always. It can be also money, because especially state-owned entities do have claims under their contracts. But if you are thinking about an investment arbitration setting, most of the time what the respondent state wants is the problem to go away with as little expenditure as possible. So that's what the states usually want. And in order to do that, and just to briefly comment on what we were discussing about doing everything in-house in-house or outside, yes, we do have this interesting example of US who never lost an investment case yet and doing this only in-house. But we also have the interesting example of Argentina. After the 1999 crisis, they had a string of cases and they lost all of them and they dealt with them, they're all in-house. So maybe it's probably better to have a hybrid approach where you have some in-house capabilities, but you also rely on outside counsel. But my experience with working with state and state-owned entities actually started with a easy example which which subjected me to a longer learning curve. My first case was Tulip versus Turkey, a real estate development project that was handled by a Dutch investor in Istanbul. But since it was a real estate development project, the in-charge entity of this was actually a state-owned entity, a commercial company that was designed for real estate development for profit. And there was obviously an issue of attribution, which actually what made the investor lose the case. And in that case, I was like, everyone was talking about, oh, it's very difficult to work with states as clients. And I was like, no, this is fine, because we were working with a state-owned entity that was designed for making profit. So when you have that entity as your client, it's not very different actually from having a commercial company. But if you do have an SOE, a state-owned entity that is actually undertaking a public service or a state's function, for example, let's say importing natural gas into the country, then everything changes. Because the whole idea, the whole reason of this entity is very different. It's not about making profit. It's not about making fulfilling one single obligation. When you think about a company like that, their entire function is about the energy security of that country. So they have very different concerns. They have very different ideas, and you have to take these things into consideration. For example, again, if we go to the natural gas example, before the Ukrainian war, all private companies, and EU has successfully privatized the energy market, especially in Germany and Spain, all of these companies' concern was one thing: get your gas contracts linked to a hub pricing, because there was gas hubs, especially in Germany, Spain, and France, and their prices were significantly lower than long-term oil-priced gas contracts, which was the standard contracts. And everyone was saying that, oh, see, that's why privatization works, that's why you need to liberalize all the markets and everything. And when the Ukraine war started, it changed so dramatically. Oil prices did not go up that much because of the OPEC intervention and the US actually intervening. So oil-linked contracts remained, but hub prices, because most of them were Russian gas-dominated hubs, they almost tripled overnight. So when you're thinking about when you're representing a state-owned entity, the state-owned entity also has these questions in mind. If they have this goal like this, but as counsel, you should be also thinking about these things. And also, as you had rightly said, it is also about politics, and I don't mean it necessarily only by with a bad connotation attached to it. There will be politics involved in this, and it will not be only about what do we do to make sure that the ruling party has better chances in the upcoming election, but it will be also, you should also consider when forming a strategy that may lead into short-term benefits in the case. But if it's an ongoing contract, if it's not terminated, what will happen in the long term? You have to think about this. You have to think about the current state of the economy. If the country is going through a crisis, and at that point, a short-term gain or a short-term loss may mean way much more than it would to a commercial company. So I think these things that you should really consider when building this. And obviously, just one small remark on the budgets. Well, I'm not saying getting a budget from a company and then getting a board approval is easy. It is as difficult as it can get. But when you're talking about taxpayers' money, there are two things: very stricter compliance rules that are imposed on the bureaucrats. And I have seen so many times, and I'm very happy to see that I have seen that you have you have very conscious people as high-level brokers that they know they are dealing with taxpayers' money. And I would rather have a difficult budget discussion with my client than to have a broker who doesn't give any care to whether it's taxpayers' money or not.
You are out of time, obviously, but this encroached into your discussion time, so it's okay. No, thank you very much, Alp. Yes, you have covered it quite nicely. I mean, what I've been wondering, what I haven't heard, and maybe I would then also like to hear all of your views. I mean, you've said there are different there are different ways how you deal with a client if it's really about these kind of interests. But what I'm wondering is the settlements. So negotiating a settlement when, I don't know, I am a CEO of a small company, it is my money, I know, okay, does it make sense to not take this money, what I have or not, or whatever, like you really look at it at from a more commercial perspective. But of course, the government officials that are negotiating things, they have a lot of different things on their mind. They don't want to be put into, this guy gave this investor, I don't know, 500 million for nothing, or, or put into prison in some points, so do you have any views on that, any experience on that?
Well, I think there the first and the foremost, the most important thing is the legal structure in place that actually says who is responsible for negotiating a settlement, where will the money come from, whose budget that it's gonna go into. If you do not have these things, just forget about it. You can't have a settlement in a state-involved arbitration. But even if when you have that, I think, and I think you can tell a bit more on this. But some brokerages and some systems, and I think it changes from state to state. Some brokerages can be courageous. Like they can say that, okay, we looked at the case, we got advice from outside counsel, and then it looks like we're going to lose this case. So let's try to make sure that it becomes as minimal as possible, the financial loss that we are covering. But there are some then brokerages, and it's a part of and I'm not sure it's a person thing, but it's a rather systems result on that person, that they can't be that courageous. They will simply just say, okay, instead of me saying that I'm paying 100 million, let's pay 100 million to an investor, I would rather live with 3 foreigners sitting in an arbitral tribunal saying that you pay 500 million to the investor. So I think that's a bit of a cultural thing.
Maybe just to add to what I has just said, I mean, settlement, whenever a state is involved or a state-owned enterprise is involved, that can be a very difficult thing, because the first thing that comes to people's mind is who's going to be criminally liable for that. I mean, if I get a final award or a final judgment and I have to pay it, so be it. It's not my money, it's taxpayers' money, it's the company's money, but I'm not liable for that. So to make it happen, and I have to say we've done it several times successfully. I mean, they're confidential, so I cannot discuss that, but nevertheless, I mean, it takes a lot of effort. It takes a lot of analysis, a lot of sign-offs, a lot of different opinions, expert opinions, and so forth, whether what you're getting is actually worth it, or whether it makes sense, taking into consideration all the possible implications, including the costs, the exposure, and so forth and so forth. So it is problematic, it's a difficult and a complex thing, but it makes sense in the end.
Thank you, David. Natasha, how does it work with the state attorney's office? I mean, I assume you have, let's say, authority to settle some of the cases. I don't know, with some of them, maybe it has to be the government who decides. I have no idea. So how does it work in Slovenia when you are negotiating a settlement? I'm not suggesting that you should settle your arbitrations, so that just as a disclaimer, yeah.
Well, except the decision in our state attorney's office law that we are competent for representing the state in international arbitration proceedings, there is no legal regulation of our work in this sort of proceedings. So To be quite honest, we are still looking for the ways how to do it, to be legally consistent and legally right. But I cannot give you a very concrete example because we have not come so far to really enter the real negotiations. But I can tell you in general terms that we, as state attorneys, I think that it would be us to negotiate the potential settlement with the assistance of our external counsel, and the final decision would be taken by the government. The money for the settlement is definitely not allocated to the state attorney's office. So in this case, it should be found somewhere on some budgetary item of some ministry probably, and not with us. But yes, I agree what was already said. This procedure is quite complicated. And especially, it is very difficult, from my perspective, to take the decision to settle because of the reasons that were already mentioned. So the decision-making process and the final decision is very difficult because, as said, it is much easier to wait for the award and to say then at the end, well, we did everything what we could, but the tribunal decided like it did. So
when we discussed this topic of settlements, something came to my mind. Many years ago, I was negotiating a settlement with an insolvency administrator, and we talked about this with Mattia. For me, it was a similar situation because, you know, the insolvency administrator, it's also not their money. You know, do they want to give any concessions to someone, whatever? You can easily get into the, let's say, daily newspapers about this if you do these kind of things. So, Mattia, what would there be any similarities when you are negotiating with when you're you know, let's say, opposing side with the other parties in insolvency?
So I totally agree with you. If I actually cite the law, the Insolvency Act, Slovenian one, the administrator should protect and realize the interest of the creditors. So I would expect the bankruptcy administrator, of course, to work into that direction. And if I follow with a specific case that we agreed that I will address here, the first thing that I would expect of the bankruptcy administrator is not perhaps to oppose the jurisdiction of the arbitral tribunal if we already have a pending arbitration in place. And following up on this, so Peter and I agreed that I will discuss a certain specific topic that our law firm represented client in. There is no to my knowledge, available case law in Slovenia, so this might be very interesting for practicing lawyers in Slovenia. If I go a few steps back, if we have a classic civil litigation and one of the parties goes into the bankruptcy, then of course the Insolvency Act stipulates that the creditor needs to register the claim is examined, and following very complex rules of the insolvency, if the bankruptcy administrator partially recognizes the claim or negates the claim, then of course the creditor is directed in the final list of tested claim to file the lawsuit with the civil court. And of course, if the litigation was already pending, it stayed with the occurrence of the insolvency by the operation of the law, and then one needs to, as a creditor, of course, continue the civil litigation by filing a motion for the continuance. So the interesting case that we had was actually a bit different. There was a pending arbitration going on, and the respondent, which was partially state-owned enterprise, went into the insolvency. Our question in that particular case was what to do, Because if you go through the Insolvency Act, Slovenian Insolvency Act and Slovenian Arbitration Act, actually there are no rules that would govern this kind of situation. So several different interesting questions arose. What to do to protect the creditors, our clients' best interest? What is with the exclusive jurisdiction of the court in the insolvency cases? And certain other procedural issues. So my hypothesis, which we proposed in the case, was that, of course, by using analogia juris, which can be used in civil law cases pursuant to Slovenian Courts Act, the arbitration proceedings that were pending before the insolvency could continue. But then you have this problem because the court, insolvency court, directs you to file the lawsuit or to expressly file a motion to propose the continuance of civil law procedure. What to do? So our idea in that particular case was that we simultaneously propose to the arbitration that the arbitration proceedings are continued, and at the same time in parallel file a civil law lawsuit. Because of course if you don't file the lawsuit in 1 month, you are precluded and you lose your right. And I, as an attorney, we as a law firm could not take that risk. So we hedged actually by filing a simultaneous parallel lawsuit. At the same time, proposed to the civil court to stay the proceedings. And again, pursuant to Civil Procedure Act, there is no specific legal basis to discontinue or to stay the civil lawsuit proceedings. But the court did that and cited Article 205 of Civil Procedure Act as a legal basis. Obviously, we have this elephant in the room, lis pedens, so we have two simultaneous procedures. But of course, if once I will hold an order or decision from district court in Ljubljana in hand, which will say the award is enforceable, then of course I can pull back the civil lawsuit. But the client's position is protected in that way. But as a side note, obviously our laws, insolvency laws and Arbitration Act perhaps needs a revision in this respect to fill this legal lacuna or gap. Because using analogia juris, of course, is a valid and perfectly fine legal method of interpretation of the laws, but it can be a bit arbitrary because you don't have case law and you don't know what to expect from the outcome.
Now, I think we might get some case law. I mean, we have discussed this issue often in conferences many years ago. And, you know, for me, someone asked me, I'm an arbitration practitioner. So of course, this is all arbitrable. But I wanted to ask you, you know, there is exclusive court jurisdiction provision under Slovenian law, but that still does not mean that arbitral tribunals seated in Slovenia do not have jurisdiction, right?
I agree with you. Interpreting Article 5 of Arbitration Act, and at the same time, of course, using analogia juris, we can come to this kind of a conclusion. And yes, there will be a case law. District Court of Ljubljana has an exclusive jurisdiction to settle jurisdiction disputes under Article 19 of Arbitration Act, and we are expecting this decision. For better or worse, I don't know, perhaps there already was a decision, but the problem of Slovenian case law, at least at the first instance, is that if there aren't any legal remedies filed, appeals filed, we don't know what was decided at the first instance, which is a big problem. But for my detailed research and specific questions addressed to colleagues who are dealing with these issues, I think there hasn't been any judgment issued decision issued in this respect. So I'm looking forward to the decision of the district court.
Thank you very much. I wanted to ask Up, but first let me ask Jean over there. Do we have 2 more minutes, 3 more minutes? Thank you. So then it's not my fault. We discussed this over dinner yesterday. Just go ahead. I don't want to waste anyone's time. Yeah.
The Turkish guy obviously speaks too much. So.
No, that would be me. I'm the
Turkish guy. You should have thought about this before inviting me.
That's why we invited you.
Yeah, now it's on. So. Well, I just wanted to say on this that in Turkey there was a very similar case, though, about the exclusive jurisdiction of bankruptcy courts over bankruptcy claims. The creditor in, actually it was for gold sale, like gold bar transaction, and it had an arbitration clause, but the creditor wanted to get around the arbitration clause because the company was dissipating assets, so they wanted to get to the enforcement as quickly as possible, and they asked directly. They filed for bankruptcy. We can do that in Turkey and Switzerland. You can ask for directly, basically ask for directly bankruptcy. Obviously, it is then subject to a discussion before the court whether your claim is meritful, but you have to have the debt, due debt, and then you have to establish that the company does not have enough assets to cover that debt. So the courts first ignored the arbitration clause, and it went to the Court of Appeal, but the Court of Appeal actually said that, no, there are two questions here. The dueness of the debt and whether there are enough assets. As courts, we have exclusive jurisdiction over the second question, but not necessarily over the first one. If you enter into an arbitration clause, I can no longer rule on whether the debt is due, paid, or not paid. You get that decision, and when you're enforcing that arbitral award, then you can ask for the insolvency of the company in question.
While doing research for this particular case, fact pattern, we did find a Supreme Court judgment from Austrian Supreme Court, which actually confirmed our position. Of course, I'm no expert in Austrian law, but the interesting question that would arise here procedurally would be, what if a third party, third creditor, would oppose the claim? Because obviously that creditor was not party to the pending arbitration procedure. What to do with that? Because immediately, if you continue the arbitration procedure, then you have this question of a right of access to the court, fair trial, etc., etc. So
to open it up,
this needs to be definitely addressed in our laws.
Well, thank you very much. Thank you, our magnificent speakers. Now we hear that we are encroaching into a coffee break, so we will just leave. But thank you very much, everybody. And
thank you, all the panelists, for a great discussion. So, as Peter said before, let's have a coffee break. We earned it. So, 15 minutes. Let's say 5 minutes past half past 11. So let's continue with another session after the coffee break till lunch. So I welcome all the panelists and the floor is yours. Thank you.
Thank you so much. Good morning, ladies and gentlemen. Spoštovane kolegice, spoštovani kolegi, lepo pozdravljeni. It's a great pleasure to be here. My name is Petra Richar. We have been duly introduced, so thank you for that at the beginning of the conference. But if I may, just spend a few minutes, because I've asked my panelists to give me 3 points that they wish the audience to remember about them. So I have collected very beautiful answers, and I allow myself to read them to you. I will start with Tomislav Boric. Is a professor and deputy head of the Institute of Corporate and International Commercial Law at the Law Faculty of the University of Graz. He has asked me to introduce him to you with 3 distinctive features. One is integrity and independence. The second is multi-jurisdictional expertise and economic approach. And the third is long-term experience and academic standing. And I will now move to Christopher Seppälä. He is joining us today only online. He was not able to attend in person. And the 3 points that he wants you to remember him about is that he acts as an independent arbitrator and legal consultant and has served as counsel or arbitrator in hundreds of international commercial arbitrations, including multi-billion-dollar construction cases of the greatest legal and factual complexity. And that indeed is true. Everybody who knows Christopher Sepala knows the work that he has accomplished so far. He is a former Vice President Emeritus of ICC International Court of Arbitration and legal advisor to the FIDIC Contracts Committee and the author of the FIDIC Red Book Contract. This is a close-by-close commentary on the FIDIC Red Book, and it was published in 2023 for all arbitration practitioners doing construction disputes. This is a second Bible, if I may say so. Christopher is a member of the New York Bar and a member emeritus of the Paris Bar. The third panelist is Nastya Melak. She's a partner at the law firm Jadek & Pensa. She mostly works as a transactional lawyer, but with her background in arbitration, she gives dispute resolution clauses the same attention as limitation of liability clauses. This is a rare exception among the transactional lawyers who usually do the dispute resolution clauses at midnight. That's why they are called midnight clauses. So I submit to you that Nastya is a bright exception to that. She is surprised at the number of times she had to interpret unclear and sometimes even pathological arbitration clauses in contracts. And last but not least, Nate Slahne has been working for one of Europe's leading energy companies for 8 years and manages its activities on the Slovenian market. He focuses on long-term investments in renewable energy. He has extensive experience in the international business environment and in managing long-term and demanding projects. Nate remained a lawyer at heart and is a strong supporter of arbitration. He is also a member of the Ljubljana Arbitration Center's board. So much about my panelists. I'm really happy to be here, and we will start with the first panelist, Tomislav. The floor is yours. I am not sure anymore how the slides will be moved. I understand that it is here that you can move your slides, and otherwise we have full assistance in the back. Tomislav.
Ladies and gentlemen, it's a pleasure for me to be here and to have the floor. So, Petra, thank you so much. And don't worry about the mistake of the name. You know, as somebody born in Austria, I'm used to that. So don't worry. Yeah, it happens. I'm very happy to be here because if I look to the audience, I see practitioners. I see people from the business, and I'm really very happy. And I do apologize, Professor Belli and Professor Riavec, but I do like to speak to the business community, especially if we look to the title of my presentation today, and that's about dispute avoidance through contractual risk allocation. And I would like to kindly ask you to draw the attention to the subtitle. The subtitle is about how can effective contractual risk allocation prevent disputes when carry out projects. And that's very important to highlight the last word, projects. So we are talking about projects. And if lawyers talk about projects, they don't know what it is about in general. Sorry, I don't want to blame anybody, but in general, we have difficulties because we don't learn it. Yeah, we learn how to make an explanation and how to maybe also to make a contract, to write a contract, but not how to handle a project. And I think this causes really problems for lawyers. And both the contractual risk allocation and dispute avoidance are key elements when it comes to managing project. And I think it's very much about how to manage a project. Yeah? And that's so really important. And of course, the more complex a project is, and we already heard about the complexity at the first panel about the state. If the state is involved, then later on we will hear in the third panel about the construction cases when FIDIC is also involved. So I think this is something what is important, because we are talking about risks which are linked with projects, and a project needs a very thorough risk management and the risk management plan. So the more complex a project is, the more it is necessary to have such a management plan. And of course, such a management plan has typically to include also the dispute avoidance mechanism, and that's something what I wanted to highlight. And not only the management of a project as a whole is necessary, but also throughout the life cycle of a project. Yeah, so that's so important to have in mind as well. So I have the next slide for my presentation would be there are some questions which I can do it by myself. Sorry, I forgot it. Oops, so to get back. These are, yeah, exactly. Sorry. These are the questions which I have raised. I have raised only, I would say, a few important questions. One is about which risks are most commonly involved in contractual agreements. So the lawyers here, the counsels, do know that we talk about contractual agreements, we talk about risks, we talk about financial risks. We also have performance risks, what of course lawyers like very much. Performance, non-performance. We have compliance risks more and more. We do know, we have learned from the first panel, we have more geopolitical and geoeconomic risk, which we're not aware about a few years ago. But this is very important to have these geopolitical and geoeconomic dimension as well in mind. So, but in general, we have to say that, of course, the risks depend on the type of project. Yeah? The type of project defines then the type of risk which we have. So that means we do have different types of risks to consider. These legal and compliance risks are very often linked with the, we have to say it, with the ambiguous wording of clauses. Yeah, and also these ambiguous wording is very often linked with the different jurisdiction, with different legal traditions, legal cultures, also the knowledge of language. Yeah, what is about the, we all are aware. I'm a comparatist. I do apologize, but civil law and common law are really an issue for everybody who is really working in an international surrounding. So this is something what we have to have in mind. So these are a few risks. And what does this, the next question would be here, what does contractual risk allocation actually mean? Yeah? It means that we have to be aware about a risk management strategy. We have to develop it if we are trying to execute a project. And that means notwithstanding the concrete contract type, we have to try to establish an effective risk management strategy. And contractual risk allocation, as I define it, is a mechanism for defining the distribution of potential liabilities and responsibilities between the parties. Yeah, that's a very nice legal definition how we lawyers see this management strategy. When we talk about the clauses which may be included in contracts for effective risk management, then of course we have to have in mind that we may use indemnity clauses. Force majeure would be one, again, having in mind this geopolitical situation now, or COVID warranty clauses, and these clauses are really necessary to have in mind. Which contractual relationships can benefit from the inclusion of such a dispute avoidance mechanism? I would say that of all projects and all contractual relationships may benefit from them, and it depends, of course, of the project. So the more a project is complex, and the more it will have a long duration, and again, different languages and jurisdiction, the more it will be then necessary to use such an approach. Let me come maybe to the next step, and maybe let me come, maybe due to the fact that I'm running out of time, to the key takeaways, which in my conclusion, the conclusion would be that here the allocation risks in contractual relations, the allocation of risk is one of the key factors for a successful project management, and throughout projects whole life cycle. This is something what I want to emphasize again. Dispute avoidance is in a certain way a meeting point between project management and legal protection. So these two dimensions, the economic approach, the management approach, having in mind all these different management project methods which we have to use, and these legal protections are very helpful. Thank you very much.
Before we let you go, the title of our panel is multi-tiered dispute resolution clauses, and unfortunately 10 minutes is not enough for your presentation, which is really full of information. The slides are really excellent. We only saw a few of them. The question for you, because our panel has to discuss multi-tier dispute resolution clauses, and we know from, in particular from FIDIC contracts concerning construction disputes, that risk allocation between the employer and the contractor is different in different books, and is very much relevant in the context of dispute avoidance. But now to you, do you think that multi-tiered dispute resolution clauses help in the context of dispute avoidance?
The answer is very simple. Definitely yes, it is. Although we may use then different methods again, not only risk avoidance methods like dispute boards, but maybe Chris will or you will later on talk about these dispute boards, or mediation. I think that's definitely helpful, and I think multi-tier is an excellent, I would say, an excellent tool or approach to take into consideration also these unforeseeable risks, which everybody has to face. You know, due to the changes of the last years, we have to be more and more aware about that, and therefore I think multi-tier is definitely a very interesting tool.
Thank you. Is this?
Sorry, yeah, this is sorry.
I see that the Ljubljana Arbitration Center has made a mix of our slides and their slides. I will try to move. Can I please have our slides? I sent you a big PDF, so just before that. These are the ones, maybe just because we are now moving more towards a specific topic of the multi-tier dispute resolution clause. And before I give the word to Christopher, I just want to set the floor and make sure that everybody's aware what multi-tiered dispute resolution clauses are. So we usually know that a contract contains a state court clause for dispute resolution or an arbitration clause, but multi-tiered dispute resolution clauses, they contain a mechanism, and the purpose of multi-tiered dispute resolution clauses is dispute avoidance. So this is where we are with Tomislav's presentation. And now moving on, maybe just for the audience to read these 3 points, this is basically the essence of a multi-tiered dispute resolution clause. Before you turn to the court or an arbitration tribunal, there is a mechanism that should help the parties to settle the dispute, to solve the dispute before escalating it to a lengthy and mostly expensive proceedings. So the first step would be to use a different method. I will move to these methods in a second. And each step in the multi-tier dispute resolution clause is designed to handle the dispute if it has not been resolved by the previous step. And escalation then is to the decision, leading to a decision of a court or arbitral tribunal. So there are many steps that the parties are expected to take before going to the court or the tribunal. And so which steps are possible? There is not only one possible step. There can be a dispute resolution clause mentioning amicable resolution, amicable negotiation. So parties are invited to first to seek to resolve the dispute or claim by friendly discussion. This is a very mild first step before going to the court or to the tribunal for arbitration proceedings. Management escalation, a dispute resolution clause can say that parties, executives, so escalation going to the next level in the structure of the company, so that executives go and talk to each other and maybe try to settle the dispute before going to the court and tribunal. And then there is mediation and expert determination. And I would just like to show you these two possible clauses before we give the word to Chris. And I noticed that Chris did not have a slide with DAB. So this one is the mediation. This is a clause that is commonly, if it's a multi-tier dispute resolution clause, has a similar wording. It says that the first step, if the parties cannot resolve a dispute, the first step is trying to mediate a dispute, find a solution with the help of a mediator. Mediator is usually not, or as a rule, not acting later as an arbitrator. There are law systems and state courts where mediators can be arbitrators. That is, let's say, state court in Basel, Switzerland. But I understand in Slovenia, mediators are not the same as judges. So here, what you see, it's arbitration related. A mediator will not be arbitrator later. And a mediator issues a recommendation. And the second step, after the mediator has mediated, if the dispute has not been solved at this first tier, at this first step in mediation, then the parties can turn to point 2 of the dispute resolution clause, and these are the situations that allow the parties to escalate the dispute to the next tier. So first situation is if one party objects to any recommendation of the mediator. You see this number 2 at litra A. And litra B, the mediator fails to provide a recommendation within the stated period. And the third situation is if a recommendation has been issued but has not been respected. So in these situations, the other party can inform the counterparty that they will move to the second tier of the dispute resolution clause, that they will move to start the arbitration. So this is the very simple and basic example of a 2-tier dispute resolution clause. And now, preparing you for Christopher's presentation, this is a short version of a DAB clause. So this dispute resolution clause is included in the rainbow of the FIDIC books in their 99 edition. So Christopher, if you are listening to us, and I don't know whether you can see the slides, I've just made a slide with a shortened version of clause 20 of the FIDIC books, 99 version. With this, I maybe just for the IT team in the back, maybe at some point, if questions should arise, this is the clause that Christopher could be eventually referring to, just for your information. And now, please put on the slides that so that Christopher can start his presentation. Christopher, the word is yours.
Thank you very much, Petra, and good morning, everybody. I'm very sorry I can't be with you this morning. I would really have liked it. But thank you, Petra, for your kind introduction, and thank you also to the Ljubljana Arbitration Center for inviting me to speak to you about multi-tier dispute resolution. And I think someone is going to change I have 5 slides, just so everyone knows, and the essence of what I have to say is in my slides. So if you miss what I say, you may find it in the slides. But I think the first thing I'd like to say to you is, that I'm going to be talking about construction disputes specifically, and arbitration clauses in construction disputes. And in particular, I'm going to refer to the so-called FIDIC forms of construction contract, which are the most widely used forms of contract. And Petra's already referred there to clause 20 in the 1990 edition of those forms. I point out to you that disputes are generally more common in construction contracts than in most commercial contracts. Construction is just prone to dispute for numerous reasons we can't go into, but I just mention that to you. And for that reason, the FIDIC forms, the most widely used international construction contract forms, contain detailed procedures for the resolution of disputes because they're so important in construction contracts. Perhaps we could turn to the next slide, please. Now, construction disputes come in all shapes and sizes. You can have small and or simple ones that are relatively easy to resolve, or you could have large or complex ones which require much time or may require much time and attention to resolve. There are naturally many more smaller disputes than there are big, complex disputes. That I don't think will surprise you. But that's, in summary, a few words about construction disputes and their nature. So what is the best way of resolving them? And if we could look at the next slide, I think now, FIDIC's approach, FIDIC is the International Federation of Consulting Engineers. Now, their approach is that disputes should be settled as promptly and inexpensively as possible, which is just a commonsensical proposition, I think. But so FIDIC's aim is that the small or simple disputes be resolved by a quick and simple procedure, and large, complicated disputes, you try and resolve them by a simple procedure if you can, but if you can't, then you need more complex procedures to resolve them, which I will describe. So, to address this situation, FIDIC has developed over the years a multi-tier dispute resolution clause, and I'm just going to summarize it it's in 4 points. The first tier, or the first step, if a dispute arises under a construction contract, is it should be submitted to the employer's engineer. Under FIDIC contracts, there is the engineer engaged by the employer and who administers the contract, and that administration includes assisting in the resolution of claims and disputes under the contract. And I think Petra raised the question about, well, there's no mediation, perhaps no mediation role in FIDIC contracts. Well, actually, the employer's engineer, although he's engaged by one party, he's meant to act fairly and independently between the employer and the contractor, and thus to act as a kind of mediator in the first instance. But if he can't resolve the claim or dispute in an amicable way, then he makes a determination of that dispute. He actually makes a decision on the dispute. So that's the first step. The second step is that the dispute is not resolved by the engineer. It is then can be referred to, or needs to be referred to, a dispute adjudication board. This is what it's called under the 1999 contracts. Under the new forms, it's called a dispute, not just adjudication, but I'll think of it. Anyway, dispute avoidance and adjudication board. So it's DAAB under the new contracts. So and that board now seeks to again to see if it can resolve the dispute amicably. If not, it then makes a decision on the dispute. Well, most disputes would be resolved by this point under these procedures. In other words, they'd be resolved under the first or second tier. But some disputes are just so complex, they are not. Both parties say they're dissatisfied with what the dispute has done, and they want to, and they're ready to take the matter further. Well, there is a further step before arbitration, and that is that the parties are required for 56 days to attempt amicable settlement. But it's also provided that if they don't attempt amicable settlement within 56 days, then after 56 days, they can begin, one of them can begin arbitration. You might ask, why this time limit? Well, if you don't have a time limit, one party or the other can always argue that the other party has not attempted amicable settlement. So to overcome this difficulty about when is amicable settlement, when are attempts at amicable settlement finished or completed, we put in a time limit, obliging the parties to attempt amicable settlement within the time limit. But if they don't, then in any event, they can begin arbitration after 56 days. And then if that has also failed, that amicable settlement procedure, then the last step is they can refer to arbitration. Then the next and the final slide, please. As you can see from these steps, they are progressively more formal, more thorough. The DAB is much more thorough than the engineer normally, and arbitration is much more thorough than the dispute board. They're more time-consuming, and they're more expensive progressively, except the amicable settlement procedure, the third step I've referred to. The goal is then to filter out and get smaller and or less complex disputes settled in the first tier by the engineer, or in the second tier by the dispute board, if possible. Another thing to note is each step is mandatory. It must be complied with. You cannot get to arbitration without going through all of those 4 steps. And if you try, you risk having your arbitration dismissed as inadmissible because you haven't complied with conditions to arbitration included in the arbitration clause. So thus, to get to the last tier, to get to international arbitration, one must have complied with all of the preceding steps. So my takeaway is this: if you ever see an arbitration clause and you see some things that have to be done before arbitration, I would say, if you're the claimant, be very careful and see, are those steps mandatory? Do they say you must comply with these steps or you shall comply with them? Then be sure to comply with them before you begin arbitration. Otherwise, your arbitration may be dismissed because you failed to comply with conditions to arbitration. Similarly, if you are the defendant in an arbitration and you see the arbitration clause contains some steps before arbitration, well, then you want to make sure that the claimant has complied with those steps, because if it is not, you can have the arbitration dismissed as inadmissible. Thank you very much, everyone. I'll stop there. Thank you.
Thank you, Christopher. If I may, we're still within the time limits to ask you two very short questions. Are you maybe aware of any statistics as to how many disputes actually settle or respect the DAB's decision and end at the level of the DAB decision? In other words, do not go further to arbitration. Is there any number or statistics that are known to you?
Yes, that's a very good question. Thank you, Petra. In fact, until recently, there was very little information on this subject. But last year, King's College in London has published a survey on the efficacy of dispute boards. And it found that the great majority of disputes were settled at the level of the board and did not go to arbitration. And it also found that if a dispute did go to arbitration after a dispute board decision, the result in the arbitration usually closely followed what the dispute board had found. In other words, the dispute board decision was a good predictor or a good estimate of what ultimately would come out, and thus kind of renders arbitration sort of futile in many cases, not in all cases, but in many cases. So the statistics are very supportive of the use of dispute boards in major construction projects as provided for in FIDIC contracts.
Thank you so much. I wanted to ask you to make a short description of the DAAB, dispute avoidance clauses in the 2017 contracts. I'm not sure whether we have enough time. If I could ask you maybe to describe the difference between the two clauses in the two generations of the contracts, what would be your answer in one or two sentences, just for the audience to understand that there is a difference depending on which contracts they use?
When the dispute board was introduced for the first time into the FIDIC contracts in the 1990s, it was designed to replace basically what previously had been a decision by the engineer. So the idea was to have an independent body, a dispute board, make decisions on disputes under a contract instead of the engineer who had previously done that under the early FIDIC contracts, which had been based on the English tradition. The difference is today, the emphasis in relation to dispute boards is on dispute avoidance. In other words, their primary role today is considered to be meeting with the parties and seeking to avoid the dispute, and thus avoid actually making a decision on the dispute, but trying to assist the parties to amicably settle their dispute.
Thank you so much, Chris. So I would just like to inform the audience that Chris will be with us again at the next panel. So, Christopher, for you, it's a thank you for the moment, and please stay with us during our panel, and we look forward to hearing you then again in the next panel. And I will now move. So I've been standing here because I just want to make sure that Christopher really hears me, because I was told that one needs to use the microphone. I hope it worked well. I will now move to my colleagues to the next panelist. Thank you. Okay, so we're moving to Nastya. You have seen that we have had two very experienced panelists working with slides. Now we have two senior panelists working without slides, and it will be more of a Q&A session, and we would be very happy for the audience to engage in our discussion. Nastya, I will ask you some questions. Maybe the audience will intervene. You are a transactional lawyer, you're counseling parties. And in which circumstances would you, as an external counsel, advise the client to use a multi-tier dispute resolution clause?
To perhaps start with something a bit controversial, I would say never, because it really shouldn't be the counsel that asks the party or suggests a dispute resolution mechanism to a party, it should really be driven by the party's needs, their requirements, and perhaps some of their internal policies that they have. If they do have such a thing, it is, of course, it can be really welcome, but I think it should never be driven by the councils themselves because they think it's very interesting, they think it's sexy, or it's something that they heard at a conference. It should really respond to the needs and requirements of the party. This is not to say that I am against dispute avoidance or negotiations, amicable settlement, or mediation. Really the opposite of that. As a transactional lawyer, my goal is to keep the disputes at a minimum and for everyone to be somewhat happy at the end when they reached, hopefully, a conclusion. So it goes against me to really push for a dispute. But in my experience, what really happens if you do have a dispute, parties never just file a submission to the arbitration, or they really, really rarely do. And they never just file a claim in court. They do try first to settle. They do send some letters, first emails, then letters, then attorneys' letters. And then you do try to persuade them, maybe it would be a good time to meet, especially if you have a very expensive arbitration clause in. You tell them this is going to cost you, maybe we should try and try to settle or see if we can meet somewhere in the middle or close to where your wishes are. So I think it really happens in practice quite a lot. And I think if you don't have a very specific multi-tier dispute resolution, and this is not talking about construction disputes, I think it's widely accepted that they're very, very useful there and everybody's used to them. But in all other cases, it also awards the clients to some flexibility at the stage of a dispute. What will we go for? Will we involve lawyers? How long will we try to settle? Will we go for mediation? So there is some flexibility. And I don't think at the stage of a dispute, I think it's really hard to agree on an arbitration clause, but it's not that hard to say, let's try one last time and try to settle this dispute.
But Nastya, let's say you're advising a big Slovenian company and you are drafting the agreement for them, and the client has had some bad experience with disputes, and they ask you to please insert a two-tier dispute resolution clause in their contract. What would be your advice? What are the do's and what are the don'ts?
So, of course, when the client suggests that, I think it's a good opportunity to probe further. Are they aware of what this brings? I think it's also important to inform the parties of the possible pitfalls. You really need to comply then if you come to that stage. But I think for me as a lawyer, and I think for everyone, even in the company, I think legal certainty is of utmost importance. So the inclusion of very clear and precise wording in the clause, I think is really important. To have clear deadlines, so you know how long you need to try. So you don't have to then rely on, well, I was trying, but the other party was not, so it was all futile. You just have a clear deadline. You need to try for that amount of time, or what is the exact process.
And if you include a multi-tier dispute resolution clause, do you see any additional risks relating to disclosure and confidentiality, or is this a no-brainer?
I think there are, definitely. So I think another point would be to include standardized clauses, especially those that refer to certain additional mediation or other rules, because those can fill in the gaps that the parties don't think of at the time of including that into their contract. And perhaps importantly, with confidentiality, if you do have a standardized clause that refers to rules, or it will be solved in a mediation center, so to speak, you will have the rules govern the confidentiality. And there, even if you didn't think, or maybe your confidentiality clause or agreement doesn't cover that part, I think there are important protections in the standardized rules that really benefit the parties, that really we don't have time, even if we don't treat it as a midnight clause, we don't have time to think of everything. And perhaps just one more word on disclosure. I think it is important to also inform the parties to take a bit of care when they're negotiating or trying to amicably settle a dispute. The procedural rules, for instance, the IBA rules on taking of evidence, and also Slovenian procedural rules, only award limited protection of not submitting that the evidence in the later process. If it's a bona fide settlement offer or documents produced for the purposes of settlement, those are protected, cannot be. But parties could. I think it's just important to be aware that it could also be used as a sort of fact-finding exercise. What do they know? What they maybe have? What are they relying on? So it's just makes sense to come into that process with eyes wide open.
Great. That's a great practical advice. So maybe just from the perspective of an arbitrator, it's also useful to include a confidentiality clause in the arbitration clause. So some contracts include confidentiality provisions in the contract themselves, but the practice has shown that sometimes this is not sufficient. Protection. So it is sometimes useful to include an extra confidentiality clause in the dispute resolution clause. And now I'm coming to you again with the last question. Now you have a client who is facing a dispute, and the dispute has a reason, and the contract includes a multi-tier dispute resolution clause. I'll make it more difficult. The dispute resolution clause does not contain anything about confidentiality, and neither does it contain anything about the disclosure. And what would be your advice to them?
Okay, so firstly, if there is an existing dispute and there is a multi-tier dispute resolution clause, the clear advice would be follow all required steps, follow all the specific deadlines that you have in. You really need to try and make it work. You've committed to this multi-tier arbitration clause. You now need to properly engage. It is true that sometimes parties will think, well, this is now just a burden to me. I hate the other party. I don't want to sit in the same room with them. Yes. But in that case, I would still say, look, we need to be aware of everything. We need to show that we've complied with the rules. You need to go there and you try to help them sort of properly avoid the dispute. But if that's not possible, at least show up. It shouldn't really be, I don't think this is I don't want it, shouldn't really be an answer, because it could cause more problems along the way. But if both parties are like, we absolutely don't want this, we have nothing to speak about, see you in arbitration, see you in court, I would suggest at that stage, do take a written note of it, that both parties agree, we will not proceed, we don't think this is appropriate, and you just have the will of the parties on a recorded statement between them both. And then I think it's okay to proceed to the next step, even in advance of that. There might be, this is perhaps a Slovenian specific matter, there might be one thing. Sometimes it's quite surprising that clients sometimes come to you with their dispute very close to the statute of limitation deadlines. In those cases, and Slovenian law is also quite strict as what you can or cannot do. You cannot agree to extend the statute of limitation periods. You cannot agree that something does suspend it. It's just really a court or arbitration procedure. In that case, if we're nearing that, I say, we will likely have more chances persuading the arbitration not to dismiss the dispute than because the other party will just calculate the deadlines, and it's a real risk in that case. And on the other, as I previously said, I would just advise always the clients to think about the possible problems with the process, with the confidentiality and the disclosures along the road.
Thank you so much. So we've heard from Chris that non-abiding by the multi-tier dispute resolution clause under the FIDI contract is a no-go. So there can be clear problems if you don't. You've said that based on the parties' agreement, the parties may skip. If I may add a short note, in practice, if the parties do not abide by the multi-tier dispute resolution clause, this can really lead to problems when they reach the stage of arbitration, because if you don't have it written black on white, as you stated, the one party can change their mind, and then they can argue that the arbitration may not proceed. So then arises the issue of admissibility of arbitration, and the arbitral tribunal needs to render an award on admissibility. It's not on jurisdiction, it's the question of admissibility, whether or not the multi-tier dispute resolution clause has been respected or not. So very careful with that.
Absolutely very careful. I think it needs to be a real risk to your own statute of limitation sort of getting away from you if you follow all the steps and the deadlines. I think that is the only way, and if it's really clearly non-binding. But I think the last thing to say is, if you do follow all the steps, then in the dispute stage, should it come to that, there won't be tons of argumentation why this is inadmissible. You will focus on the heart of the dispute. You won't focus on the procedural matters. Those are fun for us lawyers to sometimes think about, but they're really not at the heart of the dispute. The clients don't want to spend time and pay lawyers' fees to do that. It's better to just go on, do the 30, 45 days of negotiation, mediation, whatever, than to spend time arguing about it in the arbitration process.
Thank you, Nastya. And now, last but not least, we're moving to Nates. And Nates, with your managerial background, when is it beneficial for a company to include a multi-tier dispute resolution clause, and when is it better to avoid it in a contract?
May I say that some general rule here could be that when you are involved in long-term relationship, when you are involved in a project that it's long-term or contractual relationship, where you have, let's say, when you build a trust with the party, with the other side, and you are involved in a long-term business, then of course multi-tier dispute resolution clauses are very beneficial, because they give you a structured way how to approach the problems during the relationship. And they actually are seen as a de-escalation mechanism, because a lot of disputes, or I may even say problems, challenges, can be then solved in early stages. When you are involved in a business relationship, in contracts which are short-term, or which are, let's say, transactional or simple, and especially when you predict that non-fulfillment or problems on the other side could cause you a significant damage, then multi-tier dispute resolution mechanism can be a bottleneck. And that's why you need to, when you are applying this mechanism in the contract, you need to think about the risks. You need to test your contract in different scenarios, and then you can decide what is the most appropriate mechanism to the contract. And then I also believe it is important to respect the culture, or let's say inside the company. If this is something that is familiar to the company, to the employees, if you have a legal department which which understands this, if you have an engineering department which is familiar with the mechanism, then of course you can effectively use it. Yeah. So it depends, as a general answer, on the business relationship itself, on the merits.
And so if you have all the teams that are aware of multi-tier dispute resolution clause, so do you maybe know from the in-house counsel's perspective, what are the expectations within the company when they do use a multi-tier dispute resolution clause? Are
Yes.
the expectations that there will be de-escalation, or is this depending on a project? Other factors?
In general, it's depending on the project, but I think it's not so much different than the general expectations from a business. You need to have, so expectation is that you have an early access to dispute resolution. So that time efficiency is here very important, and predictability as well. So these are, let's say, expectations of the business, and if these key elements are met, then you can also say that this is a cost-efficient matter of a dispute resolution, and it saves you time, it saves you costs, it helps you to stay in the relationship. So these are, let's say, the main expectations, I would say, from the business, from the management. And of course, you know, in business, it is normal to discuss with the other side. So it is very important here also to have enough internal knowledge and discipline to understand when actually you started dispute resolution mechanism, and when you started only, when you ended only, let's say, discussions and going back and forward between different teams involved, and when you actually started the structured way of resolving dispute, and actually you know what the dispute is about, which is...
So back to
Yeah.
structure. Nastya said that clearly worded clauses are pivotal to any avoidance of the disputes. So clear wording, a clear wording of the steps of if and whens and don'ts. But are there any other challenges in the context of multi-tier dispute resolution clauses that are known to you?
Yes. So in general, I believe function before beauty here. So the clause, the wording should be, let's say, simple enough that your legal but also technical teams understand it. And I think this is the main challenge here, because when the dispute arises, and we are talking about long-term projects, we are talking about high-pressure environment. It is usually very common that teams who are in these early stages of the dispute involved, they are skipping certain steps, or they do not have a discipline enough to document properly. So that's why it is important to have also internal mechanisms how to guide this procedure internally. It is usually done by legal departments, which need to have a proper experience. Of course, both sides are at a certain point also including external counsels, but we usually hide them. You know, they are not at the meetings, yeah. And also I have this privilege as being in the management structure to be present also at the early meetings when, you know, there is one buzzword, you know, there should not be lawyers in this room when we will negotiate, you know, because then we will reach the business, we'll find the missing element of our successful continuation, yeah.
Very good, very good. I think these are all very useful advice. I see that we have some FIDIC specialists in the room, and there it's often said, oh, now I have trained the contractor to abide by all the provisions of 99, let's say FIDIC Yellow Book, and now if we move to 2017 FIDIC books, I will have to train the contractor again, and it's better not touch so you said as well that the implementation of multi-tier dispute resolution clause within the company stands and falls, if we want to say so, with the training within the company. So how do you approach this? How do you train the different teams so that they are aware that they have this possibility to quickly solve within an existing relationship, quickly solve issues? How do you approach your company within your company? How do you approach the teams? How do you inform them of the dispute resolution clause?
I think it's important that your processes are designed in a way that they allow this. So in our case, we really, from the start of the project, have these multifunctional teams. We have steering committees as internal bodies who are involved in the project with some experienced colleagues who are then giving advice and following the project. And then if you have a good communication and people who have experience with different projects, then you are able to guide this and catch, let's say, this behavior and early on. Yeah. So let me say the design of internal projects is important, and the maturity of the organization as well.
Excellent. Good communication, the word. We would like now we have a few minutes. I've been keeping an eye on timing. We have a few minutes left. Good communication is the word. So are there any comments, any questions, anything from the audience? We would love to engage. Please.
Hi, I have this one question that I'm really, it seems like FIDIC is reluctant to answer it, but it's with public procurement. My question is, how do you see those DAAB's clauses or some different multi-tier dispute resolution clauses? Because we have this really strict Public Procurement Act in Slovenia, which sees every amicable settings as annexes, which are forbidden after a certain percentage. If we have DAABs or some other clauses and we agree on what has been decided by them and we don't go to arbitration, don't you think it's the same as being so without arbitration? It means we agreed on that, and it's a really bad thing for the employer to just agree on DAAB decision and not to go to arbitration, because it looks like there has been, well, that they agreed on that, and it's against the 19th clause of the Public Procurement Act. This is the problem we have with FIDIC in Slovenia generally.
This is an excellent question. It is connected a little bit to David's discussion in the previous panel about the settlement, consequences of a settlement. And maybe just, I'm looking at Petja, will you be looking at this? You will be looking at FIDIC, if I'm not no? Yes. Will you be looking at this question? Because otherwise I would give and will you share with us Slovenian perspective? Okay, but we would need an answer to your question, which concerns, it's actually a question, how does the FIDIC dispute resolution mechanism fit into the Slovenian law, particularly into public procurement? David, I'm looking at you. Do you have a short answer to that? Otherwise...
No, not really, Petra, but given that I've been given a microphone, can I use this opportunity just for a short comment? It's not related to FIDIC, but I mean, I fully agree with what Nastya said, that the dispute resolution clause should primarily be driven by clients' needs and preferences. Now, the key question for us as counsel is whether or not the client is duly informed and properly informed about what that means. Just to give you an example, so Nastya and I have worked in an M&A transaction, and you have, for instance, a number of individual shareholders being natural persons. And if you don't have an arbitration clause, this will not be a commercial dispute, although in essence, it is a very commercial one. An M&A transaction can take several months, negotiations. The SPAs can be hundreds pages long and so forth. They can be very complex. You have price adjustment mechanisms, you have earn-out agreements and so forth. But if you don't have an arbitration clause, if you have a normal court jurisdiction, this will in practice mean that once you will file your claim, this will be dealt with a civil court judge. It will not be dealt by a commercial court. And the one thing you don't want is that the judge is the one to be reading the SPA for the first time, not even understanding it. And I mean, one of the key advantages of the arbitration is obviously that you can appoint experts with specific expertise who have seen, for example, a number of M&A transactions and have taken part in that and have a proper understanding. And unless you inform them about that, you can end up in a very difficult situations in a couple of years' time. Thank you.
Thank you, David. Is Christopher still with us? Christopher? No. The question.
Yes, Petra, I'm here, but I
have
had a
you
question.
back. Just my question: do you have a particular experience with the FIDIC dispute resolution clause not fitting into a legal system? Here we are in Slovenian legal system in the context of public procurement. And if so, what was the solution? How were you able to solve the issue of non-fitting of the FIDIC into the public law system of the country, of the employer?
Well, I think FIDIC is used around the world around the world in many and therefore has been used in many countries with many different legal systems, and often FIDIC contracts are used in a particular country because the World Bank or another multilateral development bank requires that when they finance a project, the project is performed or executed using the best international standard form, and that often means FIDIC. That's what the World Bank, for example, recommends, and that means, of course, the dispute resolution clauses in FIDIC, in both the dispute board and arbitration. And if that is incompatible with the procurement law, as it may be, but if that country wants the benefit of multilateral development bank financing, they will amend their law, as Vietnam, for example, has done, which is another civil law country. They will amend their law in order to permit the FIDIC dispute resolution procedures to operate there, because, as I say, they want the money that multilateral development banks can provide.
Amending the law,
but
if I understand correct, Christopher, for the sake of time, just let me make a shortcut. Amending the law is one suggestion, but Christopher, I have one question. So we all know that the FIDIC have general provisions of contract and there are specific provisions of contract. We know that states as employers or state-owned companies very often amend the general provisions, the general conditions of contract with the specific provisions of contract. And my question to you, Chris, instead of amending the law, which I assume is sometimes very difficult, would it be possible to amend the dispute resolution clause in the particular conditions of contract so that it would fit into the law procurement provisions or legal provisions of that country? Would that be a possible solution?
Yes, the answer in one word is yes.
Good. And is there a limit to the amendments to the dispute resolution clause? Is there a limit when you would say now this dispute resolution clause 20 has been amended so far that it's dangerous or the red line has been crossed? Is there any red line as to the amendments?
That's a good question. Literally, you can make any amendments you like because whatever amendments you make in the particular conditions will modify the general conditions. But FIDIC has taken the position that a FIDIC contract will not be considered a FIDIC contract if certain amendments are made. This is called FIDIC's Golden Principles. They're available on the website if you want to look at them. But one of them is that a FIDIC contract should contain a dispute board provision. So if that is removed, then I think there's a risk the contract will no longer be considered a FIDIC contract. But you can look at the Golden Principles on FIDIC's website and check me out on that. But that's my recollection.
I was actually having these golden principles in mind when I was asking you the question. Thank you so much for referring us to that. So that these golden principles are simply and clearly written on the website. So the answer to the question would be that there are certain limits to amending the multi-tier dispute resolution clauses, and maybe my advice to that would be, now referring to FIDIC and non-FIDIC multi-tier dispute resolution clauses, just take the advice of a very good lawyer when you amend the multi-tier dispute resolution clause. In the interest of time, are we still allowed to accept one or two questions, or are we? Yes? Thank you. Are there any other comments or questions or anything from the audience? Yes, please. I see that Jure has joined us.
Thank you. My name is Jure Levonik from Jadek and Pensa. I have probably a silly or trivial question, but I will ask it nevertheless. Now, first listening to Professor Boric's presentation about how we should take care of contractual, how to find the right balance in the contractual risks, and then other two colleagues, how we should draft the dispute resolution clause. Now, when we are thinking about dispute resolution clauses, as Petra, you mentioned, we first think about a midnight clause. Now, my question is, would it make sense to make it like a 9 a.m. or 10 a.m. clause? By moving it forward further, I don't know, to the first or second, or let's say the initial part of the agreement. Now, when there are so many other things we should have in mind apart from just, I don't know, jurisdiction, but so many, for example, different tiers of resolving disputes. What do you think about this idea?
Just for the audience, what we call midnight clause is not a special clause. It's just written at midnight. That's when everybody is exhausted. That's called midnight clause. And the dispute resolution clauses are, by transactional lawyers, usually drafted at the end, just for the sake of clarity.
Yeah, maybe, so from the M&A practice, it is not, I think, especially if you have a foreign investor into a Slovenian company, they generally always prefer an arbitration clause. Some of them, serial investors, they already have their favorite institution that they want to resolve disputes with. So a lot of the time, this also is included or drafted at the LOI stage. So it's not really something, especially in those, and as David correctly pointed out, in very complex disputes that don't come to judges very often. I think it's in the mind of the parties and the council as well to start thinking about them as soon as possible.
Thank you. And now to Tomislav. So risk avoidance, doing it at 9 a.m., what is your opinion?
I think it's a very good question. Thank you so much. I think it depends which kind of contract are we talking about. Is it an investor-state dispute, or is it a commercial dispute? So I think that's really that makes a big difference. I remember a case where it was a counsel to an energy company, and there we had to discuss about the arbitration clause, and it took me 1 week to discuss it. At the end, we were successful, but on the other side, the public authority said no. We are not allowed by law to take over the risk, which is more than, I don't know how many million euro, said no. That would mean that we are not, we are not acting in compliance with our legal regulations. And I said, that's stupid, you're a public representative of an institution, so you're allowed to do so. So, it took me 1 week So I think it really depends on the type of contract and of the sector of the economy which we're talking about. That's my experience.
And you know, one simple means of avoiding unnecessary risks is by using standard clauses if they suit the contract and the project. But the institutions have these standard clauses, so does the Ljubljana Arbitration Center, and they are drafted in a risk arm to avoid any risks within the dispute resolution itself.
And they were drafted at 9 a.m.
I think that's a great conclusion. If there are no further questions, the conclusion is to avoid any risks. When you're not using the FIDIC contract, that is, please use the dispute resolution clause contained in the Ljubljana arbitration rules. That's why we're here. So I thank my panelists and I thank the audience for your contributions and for your time and for your attention. We actually had a very nice slide. And next one, thank you for your attention. Thank you.
Thank you, everybody on the panel. So now it's time for lunch. We're all hungry, so we will see each other back in this room at 2 p.m. And please come everybody back so that we will continue with the discussions. Thank you. For the discussion, it's fine. I think they hear me. So it's okay you have the microphone. So yes, the floor is.
Thank you, Barbara, for giving me the word. Good afternoon, everyone. I hope you all enjoyed your lunch and had a chance to recharge a little bit, because ahead of us is the longest panel of today. We have among us an expert on delay analysis, and Mr. Teddy from France, Paris, also a member of FIDIC list of adjudicators. We may ask him to allow us maybe additional extension of time, or maybe during the presentations of individual presentations, and hopefully he will also provide us with some delay analysis methods. Approaches. Another FIDIC expert is Mr. Robert Werth from Germany, also on the list of FIDIC adjudicators, FIDIC trainer, and an expert also in arbitration. We welcome two extinguished experts in arbitration as counsels and also as arbitrators. Ms. Tamara Manasijević from Vienna and Maja Menard from Slovenia, who will give us a little bit of more insight of how to handle construction arbitration cases. Last but not least, we also want to hear some words from the constructors, and therefore we have Mr. Andrej Vance from company Rico, Slovenia, one of the biggest engineering companies in Slovenia, involved also in international construction. I'm sure all of the panelists will give us good insight in the topics that is ahead of us. We will start with issue of engineer and Robert. My question for you is: we had a little bit of introduction of engineer's role by Chris earlier in the morning session. But is the engineer only a contract administrator?
Yeah, thank you so much. You have to give me a second to answer that question. First of all, thank you for having me here. And when I have received the invitation to talk about this topic, I had a big smile in my face because I knew it was going to happen to me one day in my life, that I have to explain the role of the FIDIC engineer in front of a legal audience. And we will do that in a nutshell. Hopefully that is possible. I have very carefully listened to Chris' presentation, and I'm experienced that that takes over a lot of topics which are on the other panels as well. Just to remind that my topic is FIDIC and the engineer, a key player in minimizing delays and disputes. Before I hit both the question and the headline, I think I have to clear up a few things. First of all, there was a term frequently mentioned this morning that was letters. So in the FIDIC world, we are funny people. We don't write letters, we write notices, and we have a particular requirement for this part of communication. Another thing is, who is the project manager? And I can only share my understanding, that's not the engineer. The engineer can't be the project manager, because if you look in the contract, we have forward a lot of activities of managing issues to the engineer, to the contractor. So my understanding is the contractor must manage the project. All time-related aspects are transferred to the contractor's risk. Only the contractor knows his resources. Without knowing the resources, you can't make a program. The contractor is responsible for site safety of the site. So you don't want to interfere in this managing process, because any interference has something to do with responsibility. So we would leave it to the contractor. Is the engineer a supervisor of the works then? Again, I would have put a question mark on that. If you look at the contract, just have to check my statistical analysis, and you check for the term supervise or supervision in a FIDIC contract, let's say 99 Red Book, and you will have no matches. The term doesn't appear. But if you if you search for other terms like agreement or agree, you will find 69 matches in the entire Red Book for the term agreement, and 163 matches for the term to agree. So that's for the parties to agree, and parties must be able to manage their project. And having said all this, I think back to the rules. What was the intention, and what are the FIDIC principles? And I think it could be best summarized in a way to say the idea was that whatever needs to be discussed shall be discussed at the earliest possible way, which means put it on the table and discuss it, and of course find an agreement to settle the issue. So in this respect, in the FIDIC world, we love conflicts. Do you love conflicts? Well, yes, certainly we do, because only if we have a conflict, we know that we have a different opinion on an issue, and we can discuss around it and find the common interest or the common solution, whatever. What we try to avoid is disputes. So the little thing between a conflict and a dispute, that is what we call contract administration, and that is the key element of a FIDIC engineer. So the FIDIC engineer is called the contract administrator. That's the British term. When we look in historical contracts of the UK, they always had to appoint a contract administrator. In the Middle Age, they called it the architect, because the architect was the one who had knowledge with the building permit law or the building law. You know, FIDIC is the International Association of Consulting Engineers, so they had a problem to call this person the architect. That's why they came to the term the engineer. In modern British contract, it is called the contract administrator or the contract admin, and I think that's a proper explanation. So that is the key role. So management of the project is for the contractor, and the contract administrator, the engineer, as we say, has to remind well, both parties of the contract, that they had signed a contract and they had have an obligation to comply with the contract they have agreed. So again, that's contract administration at its best. Then we have in the FIDIC contract something which is very important in the construction industry, and that's called what we call the right to vary. So construction contracts, legally speaking, now I have to check the reaction, are incomplete contracts. Incomplete contracts because they don't contain everything which is necessary for what are the parties' obligation. A lot of things are catered for the future, for things which may happen. But if they do happen, then we have a procedure to apply, which means we may have to adjust the scope. But if we have to do so, then everything is clear. And there's a principle underlying to this. That means also a good price remains a good price and a bad price remains a bad price. So we might have to find new rates or whatever prices, and there's a principle behind that. And who has to find the right consequence of the adjustment, as we said? Oh, it's the parties. So the parties have to sit down and agree. That's more or less a principle. Then FIDIC has said, if we discuss whatever needs to be discussed with an endeavor to reach an agreement, but an agreement cannot be reached, then there has to be somebody who tells the parties where's the light. Then we go there. That's the engineer, and in contractual terms, we call that a determination. The determination is a temporary, preliminary, binding decision, as you may say, how to proceed. And we have an understanding that or it might be correct to say that a precondition for the engineer to make a determination is the parties' failure to agree. If the parties agree, there is no need for the engineer to make a determination, but if they can't reach an agreement, then the engineer has, by party agreement, an obligation to determine how we proceed. These follows the principle that we know we need to have many adjustments of the contracts throughout the lifetime of a construction contract. And our principle is that we want to have this adjustment made ex ante compared to ex post. So when the project is completed, everybody knows everything better. But we have a preference to say, if we have to adjust something today, we would like to agree on the consequence of that adjustment for the future. That enables us to have a clear contract again. Nothing is worse to have a contract with 150 open issues, where you have to pay 100 and you have to pay 50, and we don't know where it is. So it was said management of a project and managing risk is a totally different issue. To my understanding, management of the contract is for the contractor. The engineer is the contract administrator, appointed by both parties, appointed by the employer, but authority is given to the engineer by both parties as they have signed the contract, and the contract specifies the authority to the engineer. So there's nothing to his discretion. The contract is crystal clear on this thing. We have periods for the engineer to comply with this obligation. 99 less stricter, but still we have periods. Up to 20.1 is clear that within 42 days the engineer has to give approval or disapproval on any merits of the claim. In the development 2017, we have much more deadlines, so more administration activities. And I think that is the step up which we have to more or less accept. 2017 puts more contract administration issues on the engineer. And the idea is to provide more clarity, because the new definition of a dispute is anything determined by the engineer and objected by one of the parties. So we can't have a dispute without the engineer have made a determination and one of the parties has objected to this determination. That enables the further steps of the multi-tiered dispute resolution mechanism to continue, which means we have to have an engineer, otherwise we will not reach a determination to which somebody can give a notice of dissatisfaction. And the parties more or less have to comply with the procedures they have agreed in the contract. So yes, the engineer is the contract administrator. If that was a long answer, I'm done.
Thank you. Thank you. Yes, you mentioned that FIDIC 2017 provides more deadlines for the engineer in respect with the determination. However, we still see in practice the problems with 99 edition reaching or getting to the determination of the engineer. The problem is that the engineers sometimes don't even give a determination despite having a claim from one party. What is your suggestion in such cases?
To answer this in a simple way, the 2017 follow the approach, who barks has to bite. So if you announce one thing, you have to do the second consequence, which is more or less what you are criticizing on the 99 suite. Even though it's clear what somebody had to do or has to do, there is no direct sanction if that obligation is not complied with. So the engineer has the obligation to make a determination. I think it's clear that FIDIC has published the conditions. And I think here and there you could see that FIDIC had no intention to put their people in tight shoes. That's why they had given the engineer the discretion to ask for further documents and prolong the determination process, which is what we see in practice. They're asking further in order to avoid making the determination. But also under the 99 suite, where we don't have the strict dispute definition, you could refer the issue to the DAB right away if the engineer is not compliant with his obligation, and that is strictly to make a determination under 3.5.
Thank you. I have one more question in terms with engineer. What are the limitations for the employers? How to change the duties by particular conditions? Because we see very often that the engineer is required to obtain approval from employer in case before getting anything or issuing any determination.
Yeah, and most probably this habit has been introduced in the industry by the Pink Book. The Pink Book was the first standard who had published some restriction of the engineer, where it's fair to say that was always possible if there is a requirement. But what are the requirements to draft particular conditions? That is, the general conditions are against the applicable law, which is rarely the case. And the other good argument to draft particular conditions is that there is a particular need resulting from the type of the project. Again, that's very rarely the case. So we should not see too many particular conditions following this line of thought. In real life, we very often have these 88 pages of particular conditions, knowing that the general conditions are only 66 pages. So the question is, why could you correctly say they have used a standard form of contract where you have modified the standard by more than the words of the standard? The second point is, FIDIC Pink Book has said under certain conditions the engineer should require the written approval of the employer, and it was included making a determination in respect to 4.12 unforeseeable physical conditions and issuing a variation with effect of the contract price. So basically the two main elements which have a significant effect on the contract price was subject to the employer's approval, which at least the determination restriction makes a question mark whether the engineer is free in his determination. He should make a determination fair in accordance with the contract, and that cannot be subject to the employer's confirmation. It is excluded in 2017 following this logic, and I think the reference is to FIDIC Golden Principle #1, which says don't interfere in the role of the contract participant, so not the party's participant, which includes the engineer. So the employer has a duty to appoint the contract administrator and has still the duty not to interfere in the contract administrator's exercises on the authorities.
Thank you. Does anyone from the panel has any contribution to make to this? Thank you. We will now move to the second presentation, second panelist in our panel. Having discussed about decisions, we most often see the claims related to the extension of time. Please, Thierry, we would love to hear what you can share us, how to deal with extension of times, how to prepare the claims, and in particular, if this is an issue of arbitration proceedings. Thank you.
Work? Yes, this works. Okay, I prefer to stand up because I have visuals to wake you up. I'm here just very quickly. I've done 15 years on actual project and work sites, as did Robert in his past as well, before turning to consulting and arbitration. So I know how to fail a project and to deliver it late. Be assured, I know about delays because I create delays, and I will do so this afternoon. Now, I turned afterwards to consulting, and I act as a delay expert, as an adjudicator, and as an arbitrator. So I've put myself in the condition now to look at how others are doing very badly what I used to do very badly. It's very unfortunate. So an expert, and in particular a delay expert, I was reminded by Tamara that I give similar presentations almost everywhere, in Zagreb, in Dubrovnik. Now, I'm very often asked to talk about that. Why is that? Because I act as an expert, and to a lot of people, it sounds like magic or dark arts, or we don't know what those people are doing, in particular in delay analysis. Well, what an expert is doing, and in particular in delay analysis, is very simple things. We're helping an arbitral tribunal or an engineer, or depending on the proceedings, we're helping digest data. In construction arbitration, there's a lot of data. You have daily reports, monthly reports, pictures, inspection records, whatever it is. We digest all that. We understand all that. We try to summarize, simplify, and give an analysis that can be used as evidence. I will come to the delays now. And in particular for delays, we try to answer 3 questions, again, to help the determination of the engineer, or to help the employer accept that determination, or to help a tribunal decide. So, first question, impact. Question 1, what is delayed? What are we talking about? That's supposed to be factual. If you're telling me the road was delivered on 1st of February instead of 1st of January, question is answered. Finished. What is delayed? The road. Thank you very much. It was difficult. So no dark arts here. Second, how much has it been delayed? Well, I just told you, a month. That's easy. That's factual. Of course, projects are more complex, but the answers should be that simple because it's factual evidence. It's digesting a lot of data to give a simple answer that will be used. The third question is actually more difficult. What is the cause of that delay? And that's where the expert evidence comes to complement the factual evidence by analyzing the facts and trying to answer. Analyzing the facts, then trying to answer. Not making a predetermined opinion and checking whether the facts work with what I'm saying. What does that mean? Let's get visual. I have in blue, I'm in the middle. Something is delayed, something, because it started late or because it lasts too long. Then I go in red. If one activity is delayed, maybe my project is delayed. And that's the problem. That's the consequence. Consequence were my first 2 questions. What is delayed by how much? and you go to the white ones around, those are the causes. Why did we get a delay? Was it a predecessor? Was it a problem of mobilization? Was it a problem that an external party did not give whatever was needed, access, a crane, materials, whatever it is? So those are the questions that we will inquire. Now, how we do that? Let's build a house. Very simple house in 4 activities. I'm always giving the same presentation, I'm sorry, or on the same subject, because people don't want to understand. So now I've dumped it out, 4 activities, please understand. And don't ask me again next year. No, it's just to keep it simple. You know that, of course, a project is very complicated. You can get thousands, if not dozens of thousands of activities, but the principle is the same. You have 4 here, supposed to work, okay, I'm doing A, then B and C in parallel, then D. Well, in actual facts, unfortunately, things happen. And so B and C were delayed, which led to D being delayed. I'm being very, very factual here. That's my first and second question. Factually, I know there are 2 weeks delay, and I know on which activities. Okay, it requires, in actual fact, a lot of digging to reach to that, but it's supposed to be a factual picture. What was supposed to be, what actually happened. Normally, everybody should agree until that point in time. There should not be contention until here. Now, what is missing is the why. Well, let me give you the answer. The contractor delayed B, the owner delayed C. I give you the answer. Now, given that answer, and by a show of hands, you don't have more information than that. I want to know who thinks that the contractor should be relieved of liquidated damages for the 2 weeks of the project delay. Nobody's buying. For 1 week of the project delay? Well, you're not very nice to the contractor, are you? You think the contractor should get nothing? You need to choose something, people. Well, that is the actual question. And we're coming to the methodologies of delay analysis, because that simple situation could be viewed several ways. And Robert was saying earlier that it depends also when you settle the issue. If you're knowing about a subject and you forecast your delay is different than coming after the facts and looking at the planning, the situation, and trying to assign blame to someone. You could come to very different answers. So let me give you different answers. You've used or you've seen the SCL protocol, Society of Construction Law, defines by and large 6 main methodologies. If you go to more technical papers like the ASE, you get to 37, but those people are crazy. So let's stick with 6 commonly used delay analysis methodologies. The first 2 are what we call prospective. Impacted as planned, time impact analysis. Basically, they are simulations. What is a simulation? If I take back my example, is to say, look, if on day 1, me, the contractor, you had told me you would be late on C by 1 week, I'll simulate that. If I had that information, I should have told you I would finish at end of week 8. Right? So, please, I'm the contractor, Mr. Owner, you owe me a week. All other things being equal, you should give me that week. So that's the answer, 1 week for the winners. Other winners, 2 more methodologies which we call the contemporaneous methodologies, time slice and as planned versus as built. Why contemporaneous? Because the analysis is a bit different, but trying to understand what was actually during the project critical to the eyes of the people and which led to the decisions being made. Example, I look at that and I say, well, there's 2 problems occurred. One contractor one owner. Now we need to understand who bears the blame. Let's look at the contract. Let's look at the law. Do we work in the UK where the prevention principle would apply? Do we work in France where people do whatever they want? You have a different analysis which may lead to different results. And the last set of methodologies are called retrospective methodologies, whereby I simply look at the end picture and try to understand, and it's more cause and effect, try to understand what led to the final completion. What it looks like is like this. I look from it from the far end, and all I see is the delay on B. The delay on C doesn't even occur to me, because when I look from the far end, well, it's task B which drove everything. Now, I'm just playing with you, because it's simple and it's 4 tasks. But when you have, say, 10,000 tasks on the schedule, that it's not necessarily 100% properly maintained, that you have some doubts about the dates, that you have some doubts about the actual technical dependencies between activities, that's the job of the delay analyst to help with the proper methodology and to help depending on what the contract calls for. If we are before a delay, if the owner says, look, next month you will not have access to site, well, I can go back to a prospective methodology and tell them, well, if I don't have access to site next month, here is what the impact would be. Please give me an extension of time. Conversely, nobody said anything to one another. There was rain, there were problems, there were, I don't know, accidents. We can look retrospectively and try to say, okay, what should happen under the contract terms and under the law? Last slide, because else I will be blamed for being delayed again and again. So what do? Well, we look at everything there is. There are plannings, baselines, updates. There are a record of what the contractor was planning to do, how he was planning it to do, and how the execution plan may have changed as he went along on his site. There are pictures, there are reports, there are maybe mobilization of people, resources, cranes, all that kind of records, which are very useful, complemented by minutes of meeting, letters. I'm talking of all those records which are built contemporaneously, not for a claim, not for an extension of time, just to record what is happening. But from that, you can retrace a story. And you can try to be cautious to help. And here are my little accuracy and precision chart. I'm trying to help. As I showed you, prospectively, retrospectively, I could play with you and reach different outcomes. Now, you have, when you use as a counsel or as an arbitrator, when you use delay experts, you should ask specific questions. Never ask a delay expert, please tell me what has been delayed. You will get 10 different answers from the same guy, depending on the day. You need to ask very precise questions. Do you want very accurate answers? How long was that specific task delayed? 7 days or 8 days? Please focus on that and be specific and accurate. That's one question. Or please be precise. Try to tell me which was the dominant delay between 2, 3, 4, 5 concurrent activities. You cannot have everything at once, or you need to ask a set of very definite questions to be able to have an answer. The global question is a bad question for a delay expert. You would be led astray, I promise you. If I stop now and ask and open myself for questions, or later on. Thank you.
Thank you very much, Thierry, for this deep insight into the delay analysis methods. I do have one question, but I'm afraid it's not precise enough. let's just give it a try. What is common in this region is that constructor would ask for extension of time because there was a delay of just on a part of the works, claiming that this affects the total works. Is this correct approach of the constructor?
The question would be a question of timing. It's correct if and when that activity is critical to the project. If it's the one which drives the end date, that's what we call the critical path, okay, in planning. But that's actually a very good question. I've got several cases. The contractor said, look, in 2020, we had to close the site because of COVID. It's very obvious that we were delayed. 5 months closure of site. Yes, but you were not even at site. You were just ordering the materials. Materials were not delivered at site. So even if it was closed, it caused no impact, right? So the question should be rephrased a little bit is, yes, you were delayed. So we can know which activity was delayed and by how much, but did it have an actual impact? Let's go back to there.
Thank you.
May I ask you another question? Because when we look now back, and you explained there are different ways, methods, how we look to the delays. And of course, that could be a potential source of the conflict or dispute. Would you recommend maybe to define a method for delay analysis in advance in a contract and so avoid such disputes?
Well, thank you, Andrej. It's actually a very good way forward, I would think, to try to agree in advance, the same way that, for example, in FIDIC, you agree in advance that you would go to a dispute board, then to arbitration. You have procedures to settle the dispute. You know that you will have delays, so it would be wise to have a procedure to settle the delays and through a methodology. Now, we don't see that often, except maybe in the short form of contract, right, Robert, now, where it's supposed to be drafted in. Now, what I've seen that in a French contract, in fact, whereby the parties agreed that if it is a delay which is forecasted, so they know something will happen to change the execution plan, they will use, I think it was impacted as planned. If it's for a delay which has already happened, they will use impacted as planned with a cutoff after the end of the consequences of that delay. So they tried to be very specific. I thought it was good until the day a dispute occurred, and I was the adjudicator on this one, not the expert adjudicator, because they both disagreed with what they had written in the contract. Both wanted to use a different methodology at that point in time, not the same one. Yeah, people like to disagree.
Can I just add one thing? I think arbitrators would be delighted if the parties agreed on the methodology in advance. So if that is possible.
I think sometimes the answer is, well, first thing, let's not entrench ourselves into very complicated things. We can have a summary or simplified delay analysis sometimes. Don't need to go into the degree of accuracy which requires months and months of work. You can decrease a little bit the accuracy, but be precise enough for a decision or for a determination, first thing. So that could be written in the contract, that degree of effort, let's say, which is needed depending on the nature of the dispute. And then second thing is, let's try and not be distracted by the delay analysis or by the consequences in liquidated damages, in prolongation costs. Maybe there is a first step. Is the claim properly notified? Is it time-barred? Is there entitlement? Let's answer those questions first before turning to the quantification. You maybe save a lot of time because you don't need to look at it. That is rarely written in the contract, but could be a way to filter out the same way a dispute board is filtering out issue by avoiding or resolving them instead of going to arbitration.
Thank you. Anyone, any comments? Robert, maybe?
Adding to what Jerry has said, the STL protocol was developed with the aim to provide different kinds of analysis to the parties in order to motivate them to agree on which one they should apply to their contract. So the idea was pick one and agree on that, because correct me if I'm wrong, but delay analysis, if you have two on the project, they would never criticize what you have said. They would just say you have used the wrong methodology and my one is the better one, and that's the outcome. So clarifying on how to calculate avoids a lot of hours spent, cost spent. And if you have agreed on one, you just put in the figures, and that's a calculation method. So then the miracle is gone.
Yeah, right.
But as you said, we have picked up the same recommendation as this SCL protocol in the Green Book. But obviously, it's so simple and results a direct outcome, and nobody really wants it in the construction industry. So some uncertainty is obviously more seek than the clarification.
Thank you. Any question maybe from the audience? Okay, if not, maybe later on. Entering this time, while the audience is warming up, we're moving to another total different field, kind of a arbitration. Arbitration, which is often praised as efficiency, effective, very effective, flexible, especially cost-effective. Well, the priority is definitely that that arbitration is offers parties autonomy, but how to get there? Maya, please.
Thank you. I think I might have drawn the shortest straw here because I have obviously a very huge topic in 10 minutes. Extension of time, yes? Okay, thank you. So if you don't mind, I'll stick to my notes to rein myself in. Otherwise, I could go on for hours.
I think we can award you extension of time.
But no variations, right? Not gonna cost me.
We will discuss variations later on.
Okay. So effective case management, obviously, it has three key components: time, consequentially cost, and efficiency. So efficiency is about procedure and about adapting this private justice that is arbitration to every specific case. But that's also what we go around the world preaching, what arbitration is all about. So users will say, no, it's not less expensive. No, it takes forever. And all you people are about is making things complicating, involving dark arts masters and other complicated people who draw drawings and make our lives miserable. But in fact, it should be that way. We go around the world preaching this because arbitration is indeed supposed to be the most efficient means. It might cost a little bit more in the beginning, but in the end, the result should be that something is preserved and that justice is rendered in a proper way. So why is construction arbitration special in this regard? First of all, because it's statistically prevalent, and the trends show that it will remain so in terms of value, in terms of volume of cases, and in terms of volume of work for lawyers, engineers, and the dark arts masters. But also because construction arbitration has certain characteristics that put these elements of case management at the forefront, and so that they are much more crucial in construction arbitration than in other procedures. And the characteristics are obviously numerous, and when I said I'll stick to my notes to rein myself in, I have to put up a disclaimer that I've chosen the elements of discussion that I will talk today about completely arbitrarily and subjectively, so it's definitely not meant to be exhaustive, but just maybe a personal view with the double heading of arbitrator and counsel to parties in construction arbitrations. So characteristics that are important for case management is that, first of all, construction is all about it's multi-parties. So we've heard all through today the different entities and people that appear in any construction arbitration. And that means that the relevant parties or entities or stakeholders can be, there can be quite a number of them. Obviously, that might entail also multi-state or multi-jurisdictional elements that need to be taken into account. But also multi-tier, something we've heard quite a lot about today, multi-proceedings, concurrent proceedings between arbitration and courts, and also multi-contract. So because often construction projects will not be, ideally it would be just one contract, but often it's many. Also often very high value, consequently very complex claims. There are very specific types of disputes in construction arbitration. We've heard about delays, extensions of time. We've heard about variations, additional costs, price increases, and whatnot. There's also quality control, compliance, and defect issues, but then unforeseen and unforeseeable circumstances, force majeure, and third-party issues. So third parties also always, most prominently, state interference. Sometimes states will also be parties to the relationship. One crucial element in construction is obviously time. These are projects that often take a lot of time, many, many years. The dispute can be ongoing for many, many years before even it comes in front of a board, and even longer before it comes before an arbitral tribunal. But the time element is crucial also because sometimes the projects will still be ongoing, or at least the relationship will still be ongoing, and it will be the aim of the parties and the tribunal to try to preserve at least some elements of this relationship for the coming times. A big and very crucial element is something that the Dark Arts Masters are part of, is the evidence, obviously. Not only expert evidence and witness evidence, because obviously this will be at the forefront of the evidentiary phase of the proceedings, but also, and most complex, the factual evidence, the documents, the drawings, the schematics, and I will not list anymore because I'm not capable of. But these are things that are quite complicated, that are technical, and that our lawyer brain waves are not always apt to absorb. So why then, what do we need to focus on to make case management effective in construction arbitration? There's a number of techniques that are divided by different topics, or at least I have divided them. But obviously, first and foremost, the tribunal. In any arbitration, you should be mindful of who you are appointing. In construction arbitration, there are considerations that become more relevant than in other arbitrations, because it's, to oversimplify, it's easy to say bad guy, good guy, and I will decide who actually did the bad thing, and actually if the good guy is the good guy and the bad guy is the bad guy. Obviously, in construction arbitrations, there will be a lot of guys. There will be one good and one bad, but there's also 50 shades of gray in between. So what you want is a tribunal, first, that is competent. Competent in the sense of experience and expertise. You at least want to have an arbitrator that's heard of FIDIC, not necessarily of Chris Seppala, but at least of FIDIC, so that they know what they're dealing with. It's not just any contract, it's a very special contract. Ideally, you would have industry-specific, knowledgeable arbitrators. They should be, or at least have brainwaves that are able to absorb technical matters. They should be digital, nowadays, digital and IT savvy, because we will aim towards being more and more virtual and electronic and not deal with tons of paper. But above all, they should have two personal characteristics. One is the case management capacity. So it should be people who are firm and are able to conduct proceedings in a controlled manner so that it is indeed efficient and it doesn't go sideways in any phase. And the other one is one of Professor Borch's personal characteristics. It's integrity. They should have the integrity to be honest about their availability. So what we often see is when it comes, you've done the midnight clause, you've done the happily ever after part of the relationship, and then it goes wrong. You come to a dispute, you need to sit down with the client and discuss arbitration. First of all, you get through the shock of the costs and the length and all the horrible stuff, but you get to the point where you say, okay, we need to appoint someone. And inevitably, in most cases, the client will be, I want someone famous. I want someone who is well-known. Big mistake. Well-known and famous, he will already have 16 arbitrations. Whether they will have the honesty to say, maybe your construction arbitration is something that's going to take forever, it's going to take a lot of time throughout the years, and I don't really, I'm not really in a position to promise to be available, is a different question. But maybe it's better to have someone less famous, but who is genuinely available and ready to roll up their sleeves. Second big element of case management is procedure. Obviously, it's in the hands of the tribunal. The tribunal should be experienced enough and competent and able to control the proceedings in a way so that they indeed are efficient and that they take into account all the different considerations that are specific to construction arbitration. So the procedure often will have to be calibrated maybe differently or in a more micromanagerial way throughout the process from the beginning, so from the claim to the award, or at least the settlement, which would probably be the preferred option, in order to indeed make it efficient and not so costly and long. So strict timetables, we like to say chess clocks in hearings, and I promise you, we arbitrators do indeed use sometimes the chess clock principles. Counsel hate it, but it happens. Experts also hate it, but that's fine. And there are some process tools, so process design tools like bifurcation, trifurcation, quadrifurcation. Maybe it sounds horrible, and sometimes the parties are not really very happy when we say we should bifurcate, at least between jurisdiction and merits, or at least between the whole of the case and quantum, but it does make sense. It also breaks up the procedure in a way that at some point in time they might realize that it's better to settle. You have to take into account multi-party, multi-contract, multi-jurisdiction, and multi-proceeding situations. So to be able to consolidate joint parties, expand claims, restrict claims, if possible, which very rarely happens, coordinate across arbitration proceedings. As there are different contracts, there may be different arbitration proceedings ongoing in parallel. So arbitral tribunals it might be favorable for the parties for the tribunals to coordinate at least the procedural parts, the timetables, the timings, and make the best use of both sets of proceedings. Interim measures are something that I personally think is underused in arbitration, but especially in the context of construction arbitrations, arbitral tribunals could use more of this power to take into account or put into force board decisions that have remained unimplemented, or take measures to preserve assets and evidence, which in construction arbitrations sometimes are truly crucial. But above all, the tribunal should be proactive and control the process. So procedural discipline, effective communication, early guidance, and throughout encouraging settlement. One very particular feature of construction arbitrations that we heard a little bit about is that claims may not be completely crystallized. Since projects may still be living or about to be living, the parties' claims may not be defined enough. So until the abolishment of terms of reference by the ICC, this was a feature that in ICC construction arbitration was quite painful because the terms of reference were rather useless. But early determination of issues to the largest possible extent is something that favors the efficiency of any arbitration, but in construction arbitration all the more so, because at the same time, again, it helps to preserve the future relationships or the future work of the project. There are tools for tribunals. You may have heard of SCOT schedules, which is sort of a parallel to red fern schedules, which are meant for document disclosure. So SCOT schedules are charts, tables that parties need to agree on with issues that are agreed or issues to be determined by the tribunal and evidence that goes along with it. That helps the tribunal streamline the process so that there's no so-called scope creep, so that there's no going in all directions by the parties, or rather their counsel, expanding or diverting the scope, the initial scope or the real scope. So the tribunal should have the power to direct the parties and to, at some point in time, very early in the process, to define what is exactly that we're dealing with here in any procedure. In this regard, the dispute adjudication and dispute resolution boards are often a tool that should be more useful and more used by the tribunals because since it's pre-arbitral, the tribunals sometimes just go over it or beyond it and disregard it. But often the board decisions, or at least the board discussions, will serve as filters for claim crystallization. The elephant in the room, obviously, evidence management. Huge amounts of documents, huge amounts of technical data. All of this needs to be presented, processed, first collected, processed, presented, and then used by the tribunal. So the tribunal should use its powers to digest and make the parties present this in a digestible and useful way and not overplead or overburden the process with documents. Obviously, just the volume of the evidence will sometimes be overwhelming, and it's something that takes a lot of time and bears with it a huge amount of costs. But also, it will show cultural differences or jurisdictional differences, and sometimes mandatory local law requirements will come to the forefront as a sort of an obstacle to efficient case management. Obviously, the translations and the need for them is another huge issue that is sometimes used by counsel as disruptive techniques because it creates a huge delay and a huge amount of work and obviously costs. One last thing, and it's kind of a very interesting topic, are site visits. So it's useful sometimes for the tribunal, but not necessarily. So it will very much depend on the parties and on the tribunal whether it is indeed useful, to determine whether it's indeed useful. So I've seen both sides of this coin, useless trips to quite bizarre countries to see projects that are more or less finished and where you cannot, obviously, at least not with layperson's eyes, what the defect is supposed to be, because it's a water treatment facility and it works. And it's been working for 5 years. And sometimes the site visit will completely change the fate of the project and the fate of the whole dispute and the outcome of the proceedings. So to be used with caution, but if it could help, it should be used. And then last but not least, and that also helps us pre-introduce the final part after this panel, is the electronic world. So we're, seeking to become paperless. In construction arbitrations, if you are paperless, that's great. If you are paper, it could be very problematic in terms of volume of document and the digestion of the whole of it. So very shortly, takeaways. I'm finishing. Takeaways for parties. Choose your tribunal wisely. Do not overplead. Leaving no stone unturned is not the way to go. Do not document overload. You are going to drown your tribunal and they're not going to survive. Make your pleadings digestible, use useful tools. Always approach settlement with an open mind. Don't go towards, as long as this lasts, especially for counsel, I'm billing and I don't care what happens. And think of the future. The project and the relationship might have a future that you might kill with your conduct of the arbitration. Takeaways for arbitrators: be credible, proactive, manage time, control costs, balance thoroughness against efficiency. Do not forget settlement, and think about the end product, so either the settlement or the award. As the great Johnny Reeder, one of the greatest arbitrators of all time, said, be the ship's captain. It's the party's ship, they own the cargo, they are more or less rowing or drawing the sails, but you are navigating. And if there is one takeaway for both sides, another great man, Mr. Jeremy Irons, in the first and the truly original Lion King, be prepared. Thank you.
Thank you very much. You opened kind of a floor for the next presentation. You extended your time with variation, I guess. That wasn't really discussed. So please, Tamara, share with us your points of view. Who does have a burden of proof in construction arbitration?
Now it should work. Good afternoon, everyone. Dobar dan svima. Thank you very much, Petra, for the kind introduction. So I would start with a question. Why does the burden of proof matter in construction disputes? Because they are facts-driven. And in resolving factual disputes, the burden of proof plays a key role. So in this short talk, I promise, I will focus on three aspects. How the burden of proof operates, how it plays out specifically in defects and claims and in delay claims, and finally, how can tribunals and parties keep the evidentiary process fair and effective. And let me begin with the general rule. There's a principle known to all lawyers in this room, which says, actori incubit onus probatio. And in international arbitration, the allocation of the burden of proof follows very much this principle. It operates on two levels. So we have the legal burden, which is the burden to convince the tribunal in a non-liquid situation, so when neither party's position is more probable. That burden doesn't shift. It stays with the same party throughout the arbitration. And then there's this evidential burden, which is the burden to adduce sufficient evidence on specific factual issues. That burden shifts and can shift many times throughout the arbitration, depending on whose case is stronger at a given stage. What does that mean? So a party bearing the initial burden must present the prima facie case. Once it has done so, or if there is a presumption operating in its favor, the evidential burden shifts to the other side, which needs to present counter-evidence. And respondents sometimes say, well, all I need to do is to say, you claimant, you have not discharged your burden of proof, you should lose. But this is rarely sufficient. By raising objections, respondents effectively become claimants on these issues. And they must prove their affirmative defense. And if the respondent's counter-evidence is then strong enough or sufficient to shake the tribunal's conviction, then the evidential burden may shift back to the claimant. So, with this very brief introduction, I would like to see how the burden of proof shapes the dynamic of some typical construction claims, and I would start with defects claims. Under the FIDIC Red Book, the disputes often arise as to whether a defect results from a poor design, which is the employer's responsibility, or poor execution, which obviously is the contractor's responsibility. And unless the defect is attributable to the employer, the contractor bears the cost of remedial works. Now, imagine, Maya mentioned a wastewater pipeline. So imagine a wastewater pipeline project where post-installation testing reveals sags in some pipes, restricting the flow. Sags are little bellies in the pipe. So, as I have just mentioned, the employer here must establish a prima facie case that these are really defects and that they stem from poor workmanship. And in the arbitration, the employer argues that the contractor failed to prepare the bedding of the pipe trench properly. It failed to compact the bedding. The contractor replies, without producing any evidence, that the design was flawed because it failed to consider ground conditions. The area is known for clay soil, which in combination with groundwater may soften the bedding and which may cause sagging of plastic pipes that were used. The contractor said, you should have used concrete pipes instead. Now, we don't know whether clay is present exactly at these locations where defects were detected. So I ask, is it sufficient for the contractor to simply point to this another potential cause, to this theoretical possibility, in order to shed doubt on the employer's case? And this is often contentious. I would say the contractor has raised an affirmative defense, and in order to shift the evidential burden back to the employer, it should, I think, point at least to 1 or 2 locations where clay is actually present and link them to defects that are detected at those locations. So the employer may only then counter, for instance, by pointing to other areas with clay but no defects, because that would imply that indeed the installation was the problem. Needless to say, expert evidence will be central to determining the cause in such case. Now, if defects turn on what went wrong, delays, as we have heard, turn on when and with what impact. So I would like to briefly look at the delay claims in the context of the burden of proof, obviously. So take a FIDIC clause on delay damages. And for the employer, the case is very simple, or all the employer needs to say is the completion date was delayed by X number of weeks. The contract entitles me to the sum of Y. This is it. The burden then shifts to the contractor to prove that it is entitled to an extension of time. And once the contractor seeks an EOT, it is making a claim for a modification of the contract. And therefore, it has the burden of proof that the event qualifies as a delay event under the contract at all, that it is attributable to the employer, that it affected the critical path, as Thierry said, and that any costs are really time-related. The evidential burden can shift back to the employer if the employer pleads concurrent delays by the contractor. And if concurrency is established, the contractor may still receive an EOT, at least under the SCL protocol, but no costs, no prolongation costs. With this very brief overview, the question is there a golden rule for discharging the burden of proof in construction disputes? So what does, in fact, convince arbitrators? And I've read somewhere that a judge of the Iran-US Claims Tribunal once said, the burden of proof is that you have to convince me. And this is very simple, but very true. While dramatic submissions may look effective, once the arbitrators start writing their awards, they don't look for emotion. They look for structure and for logic. So I would say the party who best assists the arbitral tribunal with the facts and law, such that it presents its case, as Maya said, as simply and clearly as possible, will usually prevail. And in construction cases, yes, I agree, evidence can be overwhelming. So I'd say visuals, chronologies, timelines, they can help immensely. Just grouping the exhibits in separate folders, claim by claim, helps enormously. So, and above all, obviously, contemporaneous records carry far more weight than witness recollection. And it is often said that cases are won or lost on the documents. And my next and final point is, should tribunals give any guidance to parties on these matters? At the outset of a complex construction case, and I hope you can agree with me that it is useful, sometimes even necessary, for tribunals to discuss with the parties and clarify where the burden of proof lies, when the evidential burden may shift, how to present certain issues, and also what is the standard of proof. But should tribunals give more detailed guidance midstream? That's a bit more controversial. What do I mean by that? Is it appropriate for a tribunal to inform a party that its evidence is insufficient and invite further arguments, clarifications, further evidence? And many colleagues would say, and in particular our common law colleagues would say, absolutely not. This is assisting one party. There's a clear rule, the burden of proof, so what is the justification for not applying the consequences of that burden? Now, at the same time, many arbitration rules, including, I've looked it up, the Ljubljana rules, empower tribunals to request evidence and to establish the effects of the dispute of the case by all appropriate means. So the question is, are such interventions really so inappropriate? And I would really like to hear your views on that. In any event, because this is a relatively delicate issue, the safest approach is probably for tribunals to discuss with the parties the scope of any such guidance very early, ideally when drafting PO number 1. And if the parties agree that the tribunal may invite clarifications and or additional evidence, then no party can claim prejudice afterwards. And after all, such midstream guidance and indications by the arbitral tribunal how it understands certain arguments by the parties may help parties to identify common ground and very often also to settle a dispute, which I think in many cases will be in the parties' best interest. I hope, Andrei, you can agree with me on that. Thank you.
Thank you, Tamara. Yes. We still have the time for one more presentation, and hopefully we will get a little bit of an extension of time for a short discussion and maybe comments from Chris, as I'm informed he is with us. So last but not least, with us, the total practical view, we would really like to hear the views and experience of someone out of the practice. What are from the very beginning problems, or even not, from negotiation to conducting the contract, concluding the contract, and conducting the works till the very end when you get performance certificate.
So, good afternoon, ladies and gentlemen. Yes, I will try to give you a little bit of contractor's perspective on everything what we heard up to now. So, my background is not in the legal area. My background is engineering, and I've been with company RICO for almost 20 years as a head of environmental engineering department. And I've been actively involved in the execution of many complex construction and engineering projects in different countries where we work. So RICO is, I would say, a main Slovenian engineering company, and we work in markets of Western Balkans, up to Soviet Union, ex-Soviet Union, and also UK plus some of the EU countries. So that means that in these environments we have very different legal, cultural, and also business practices. We usually work as EPC contractor. That means design and build contracts or FIDIC yellow books. And our activities are from industrial engineering, power generation, intralogistic, traffic infrastructure, and finally also environmental engineering, which is mine area. So, at RICO, we face challenges every day that are connected to the nature of these construction and engineering projects. And of course, when operating in such circumstances, it quickly becomes clear that the method of dispute resolution is something which is crucial for every successful project. In construction, especially in multidisciplinary projects, disputes are inevitable. Not because anyone seeks conflicts, but because projects are complex, involve numerous stakeholders, and because expectations are many times very different from realities of execution. Here are some causes of disputes which are arising in the practice, but I would like to mention only a few of them and emphasize what is most critical in our practice. I would say we have, here it says changes in project documentation, but more correct would be differences in project documentation. So many times, because this project, design and build project, and here I must emphasize that mostly we are talking about public tenders and projects which are co-financed by EU funds or states and so on. So the projects have quite long duration. And during this duration, there could be changes in the legislation, in the, let's say, structure of employer and so on. And that result at the end in discrepancies between, let's say, contract, employer's requirements and so on. And of course, that means trouble and potential dispute. On the other hand, we have, as it was mentioned already before, many times unforeseen conditions on the construction site, mostly connected with the ground situation and similar things. But what I would like to highlight are delays in obtaining permits and approvals, which are mostly caused by authorities. So our practice is that because the authorities are, let's say, occupied with a lot of applications and so on, they constantly extend their time for decision by requesting from us different additional proofs, different explanations, and so on. And in our practice, we have, let's say, situations where instead of 2 months, this decision came from one ministry to us almost in 1 year. And you know what was the answer of the engineer to our claim? You didn't submit the full application, so you're not entitled to extension of time. And of course, that's again reason for a claim. We have today already mentioned limitations of FIDIC contracts, which are caused by national legislation. It was mentioned public procurement law and so on. So in the past, especially when we faced this increase of prices due to situation with COVID and Ukraine, there were not really understanding from authorities about this, and they were trying to put this under the public procurement law limitations, which in such circumstances was very difficult because, you know, when your prices increase for 20–25% and you are limited with the 30%, is a very difficult situation for the contractor and is an example again for a dispute. Finally, I would like to mention inadequate communication between stakeholders, which unfortunately many times is connected with big egos on one or other side. So, what are our experiences in these projects? I have already mentioned some, but let's say we're talking about FIDIC contracts, which normally include the option of resolving disputes through arbitration. Most of our projects, in international projects, they have such a clause. But Slovenian project typically, as we also today heard, require dispute resolution through the courts. And FIDIC contracts shall be fair, as they include rules and procedures for let's say, a balanced balance between employer and contractor, which means balanced rights, obligations, and risk. But in practice, the fact is that the consultants and some other, maybe sometimes also employers, use their power and they change the contractual provisions with particular conditions in the favor of employer. This is in almost any project, and I would like then to ask my colleagues to give me maybe some suggestions how to avoid this in the future. So many of disputes arising during project execution are mitigated or even resolved by the role of the engineer. We heard what should be the role of the engineer. And of course, we agree that the engineer is responsible for assuring that the contract is executed in accordance with the agreement. However, in practice, again, this role too often leans toward the client. And such imbalance can lead to mistrust and may even contribute to disputes that could otherwise be avoided. This is why RICO advocates for a professional, impartial supervisory function. I say now supervisory because, Robert, sometimes we have in the same person, let's say, a supervisor and the engineer, and one is working according to the contract and one according to the law. But many times it is one person. According to our view, a competent professional engineer with relevant experience and knowledge is not the one who offers the lowest tender price, which is still one of the most important criteria in our tenders, but is the one who dare to take substantive decisions and is not hiding himself behind administrative provisions. A particularly important element in this context is the pre-arbitral mechanism of the DAB. Our experience in implementing our project confirms that the value of this mechanism, especially because often employers, but sometimes also engineers, hesitate to make decisions or assume responsibility, fearing potential sanctions. In such cases, the DAB ensures that disputes are resolved quickly, professionally, and maintaining project continuity and the professional relationship among all parties. What we heard is also very important for the long term. And we heard this, I think, from our colleague from the beginning, from Turkey, who said this, but I would like to repeat the words of one of my clients who said, "I would rather pay 3 million as a result of the DAB decision than to settle for a 1 million." And that's, I think that needs no comment. So at RICO, we are fortunate to collaborate with a specialized expert, like, for example, our colleague, from various fields: legal, construction, financial, and technical. And we think that engaging specialists in all phases of dispute resolution enable us to resolve disputes quickly, effectively, and with a view to maintain long-term cooperation. However, not all disagreements can be resolved by engineer or the DAB. And in that cases, we need to proceed either to court proceedings or to arbitration. And RICO has experience in both of them. Yeah, okay. Why do we recommend including an arbitration clause? Here are some of the reasons. We heard most of them today. And if I may just highlight one of the reasons, which is connected with the speed and the cost. So we have here one example of arbitration on the area of ex-Yugoslavia. We started arbitration in July 2015, and we received the decision which is final and binding in more than 2 years. On the other hand, we have 2 court cases which you can see were started, one in 2014 and one in 2018. The first one is already finished and it lasted 7 years. On the other hand, the second one is still ongoing and also 7 years. So let me conclude, not to be too long. So, dispute in itself is not a failure. The failure is if we do not know how to solve it. And the arbitration is one of those mechanisms which allows us to, for construction sector to maintain professional integrity, seek fair solutions, and protect what is truly essential, and this is trust between partners. And finally, our suggestion and experience is taking initiative and be proactive. This is a key success factor that can help turning dispute into successful solution. Thanks a lot.
Thank you very much, Andrei. If we have Chris still with us, Chris, I would kindly ask you also for your comments to what you heard in this session with regard to the... So Chris is not with us.
Yes.
Chris? Yes.
Hi, hi, Petra.
Hi, Chris.
Can you hear me?
Yes, we can hear you. Thank you very much.
Could you just did you just want my comments on what has been said, or did you have a specific question for me?
Yes, actually, I will sum up what we heard today. So the introduction of engineer, the role of the engineer in the FIDIC contracts, and going through delay claims, delay analysis, and case management in construction arbitration, closing with burden of proof, and finally we heard the practical experience problems with changing the FIDIC contracts with particular conditions in a way that we can also say that the contract is not yet any more balanced, as we all wish to have once we apply for a project under the FIDIC contracts.
Yes, thank you, Petra. First of all, let me say I thought these were all excellent presentations, and I congratulate the speakers for all that they've said. Just at least from my experience, and I think Tamara made an excellent presentation on burden of proof, but in my experience, burden of proof has not really been an issue in the cases I've been involved in. You just need to convince the arbitrators on what sometimes is called the balance of probabilities, or whatever it's called. You need to convince the arbitrators. That's your job as counsel. And I've never worried about burden of proof and never found that really to be an issue. It's an academic question rather than a practical question. That's what I'd say about burden of proof. There is the perennial problem, which has been highlighted, of one-sided contracts. Employers or their consultants think that it's their duty to their client to write the contract in a way that's favorable to the employer. This is a problem, of course, around the world, and there is no easy solution to it. But I think the golden principles have been helpful, because the employer cannot call a contract and sell it to contractors as a FIDIC contract if at least those 5 rules in the golden principles have been observed, and they relate to things like maintaining the dispute board and having a contract with a kind of balanced risk allocation, as is traditionally provided for in FIDIC contracts. So 2 other things I would just point out. which I'm not sure they've been mentioned, but we've heard a lot about how complex construction arbitrations are, and I don't want everyone to come away with the impression that they are a kind of nightmare experience, because they don't have to be. They are complicated often, but I draw to your attention the fact that the ICC rules, not just the ICC rules, but a number of international rules now provide for expedited arbitration in the case of smaller disputes involving, so if there's a claim involving less than $3 million, for example, I think that can now go to expedited arbitration under the ICC rules, which is an arbitration which may last no more than 3 or 6 months. And as I say, the Singapore and numerous other international arbitration rules, the Stockholm rules, for example, provide for expedited arbitration. So if you've got a claim that's not worth more than $2 or $3 million, you might want to hive that off from what may be the main dispute and ensure that that is submitted to expedited arbitration. You can agree on that, and I think the ICC rules now, in fact, expressly require that claims of under 2 to 3 or arbitrations of under the $2 or $3 million go to that procedure, which is a streamlined procedure with a single arbitrator and streamlined rules. And then another issue that has come up, and particularly in relation to in civil law countries such as Slovenia, is supposing you get a dispute board decision, how do you enforce it? Well, if you look at the FIDIC contracts for the time being, they say, well, you enforce it by another arbitration. But that's rather frightening, having having to go through a full-scale arbitration, which, as we all know, unless it's an expedited arbitration, can take several years. There is, I just draw to your attention, this is something new, it's not really been developed yet, but UNCITRAL, in Vienna has, and this information is available on the UNCITRAL website, now provides for a procedure known as a compliance arbitration. And if those rules relating to compliance arbitration are inserted in an arbitration clause, or if the arbitration clause provides for compliance arbitration in accordance with the language suggested by UNCITRAL, you could get enforcement by arbitration of a dispute board decision within 60 days. So this is really, I think, a valuable development, which I think you'll all be hearing more about in future. So that's, I think, all I have to say at the moment. Thank you very much, Petra.
Thank you very much, Chris. I have a short question for our panelists in terms of golden principles that Chris mentioned once again. Golden principles were presented by FIDIC already 6 years ago. However, how can we enforce employer, investor to apply golden principles while drafting a contract?
May I just spend a sentence on the background of the golden principles? FIDIC is well known for contracts being fair and balanced. But be careful, that is a British term, so we have to allocate the British way of thinking. Fair in this respect means it has all the risk allocated, so nobody gets caught by surprise. And balance is both parties have some kind of risk. That doesn't mean 50-50 or it's whatever. That's the British. So it's fair and balanced doesn't mean it's equally fair. So you may say it's already single-sided on behalf of the employer. So when it comes to FIDIC contract, at least that is correct to say that FIDIC has drafted the contract conditions for the employer to use the project. So that's the overarching concept. So the employer is by principle causally covered using FIDIC contract conditions, as we have allocated a few risks to the employer, which we think they belong to the employer, and all other risks which are not named are the contractor's risk. And we went so far as we could think that's just still considered as fair. And if you go beyond what FIDIC has drafted over the years, it's not something somebody has woken up and said, well, I think that's correct. We have developed it over decades. And if you go beyond what we have considered as a fair standard, it's quite likely that's considered to be unfair. And based on this, the golden principle have been drafted and said, if you touch these, you will interfere in the core principle of what FIDIC has drafted, and you cannot longer call it a FIDIC contract. So what can people do? And that what frequently is done now is that banks asking employers for a confirmation that the tender is based on the compliance with the golden principles, which makes it quite difficult for a public employer to say, oh no. The same is consultant asked when they have to prepare the tender documents, shall we apply the golden principles or whatever you wish. So by this and another very important step, the World Bank has last year restructured their standard bidding documents in fully compliance with FIDIC golden principles, and they now have made them mandatory used. So that is a significant step in the direction of the golden principle. There are still recommendations and they are still wide in their content, but I think over the time they get more and more teeth and they start somehow to bite already now.
Thank you. Anyone else from the panel? Are there any questions from the audience? We are over the time limit we had already. But still, if there are some questions, yes, please, Petra.
Maybe just a very small comment for counsel in this room. So the attorneys who are acting as counsel in arbitrations. We've heard Tamara on burden of proof, and we've heard Chris who said that the burden of proof is more of an academic issue and has not been a problem in arbitrations. So I do not want to negate that, but there is a small comment that I would like to make. When you are arbitrating, it's very important, firstly, the substantive law that is applicable to the contract, and then the seat of the arbitration. Because the burden of proof may be a procedural issue or a substantive law issue at the place of the arbitration. A simple example, if you have an arbitration seated in Switzerland, the burden of proof is a matter of substantial law. And if it's a matter of substantial law, then Swiss law will determine the principles applicable with respect to the burden of proof. And you have a very useful guidance and in the case law of the seat of the arbitration as to how far you need to persuade the arbitrator. So this is just a small comment. It's a very legal comment, but it might be useful for all the lawyers in the room.
Thank you. Any other comments, questions?
Chris has said that he has not seen burden of proof being an issue in any of, I don't know how many hundreds of arbitrations that you have dealt with. I assume that you have always been involved in arbitrations involving sophisticated parties and sophisticated counsel, represented parties. That's not always the case, at least in this region. So I have seen a number of cases where burden of proof indeed, and also the standard of proof has been an issue. Also, including whether the tribunal reversed the burden of proof without discussing the matter with the parties. So I think the issue is pertinent, but above all, I think it is really important that these things are discussed at the beginning of the proceeding. So maybe that is not an issue, but that the matter is addressed. Evidence is so crucial. Everything depends on evidence. So, and it is very important sometimes to just discuss with the parties, both educated and less educated counsel, that you address these matters. Thank you.
Thank you, Tamara. Chris, do you have any comments?
Obviously, if if burden of proof is a matter of substantive law, that can be that needs to be satisfied by the claimant, like all the other elements of substantive law. So that's really all I have to add. Thank you.
Thank you very much, Chris, for your contribution. Thank you very much to the panelists, the speakers of this, our last panel. Thank you, the audience. I give now the word to Barbara to conclude this event. Thank you.
Thank you very much, Petra. I'm glad that you stayed till the end of today's conference. I believe it was a very good and very invigorating and important event. So in the future, we will make this event traditional. So I hope to see you next year again. Many thanks to all these all active speakers today, our distinguished guests, and of course, you as participants. So I wish you a safe journey home, everybody, and have a nice afternoon. Bye.